right, well, it's 1:30. I believe we're scheduled to start at 1:30 today with the Criminal Justice Reform Commission. So, Jordan, do we have folks who've joined the meeting?
Thank you, Mr. Chairman. Yes, I've noted several members have joined, and let me count here really quick if that's okay.
By the way, could you hear me okay? Okay. We ready to go then?
I believe so. I can go ahead and, would you like to start with roll or the coma notice?
Well, let's start with if you or Natalie could read the remarks, letting everybody know why we're doing Zoom, and then we'll go to a roll call.
Chairman Bennett, this is Natalie from the Office of Revisor of Statutes, and I'd be happy to read that for you guys. Due to health and safety concerns, members of the public are not in attendance at this meeting, but full access to this meeting is being conducted by medium of interactive communication, allowing members of the public without cost to listen to the meeting through the use of live stream audio broadcasting on the internet and teleconference as available. Information on how to access this meeting was sent out with a notice for this meeting. The agenda for the meeting was included with the notice and may be requested from the Office of Revisor of Statutes using the Office of Revisor of Statutes official website at ksrevisor.org. Any other documents presented during this meeting will be available on the website and from the Office of Revisor of Statutes. Each member of the commission and staff will state their name and title each time the individual begins speaking or voting so that the individual can be readily identified by remote listeners. All participants are required to ensure that microphones, phones, or other electronic devices are muted when the participants are not speaking so that the ability of remote listeners or observers to hear the proceedings is not unnecessarily impeded. Public comment will not be allowed at this meeting. During this commission meeting, the commission will not recess to a closed or executive meeting pursuant to KSA 754319. And each motion, if any, will be clearly stated before the commission votes, and the chairperson will announce the results of the final vote. And that is it.
Thank you. Jordan, if you would go ahead and call the roll.
Sure. Thank you, Mr. Chairman. Again, Jordan Milholland with KLRD. I'll go ahead and start with roll here. Chairperson Bennett.
I'm here.
Representative Owens.
I am present.
Thank you. Senator Haley.
I here.
Thank you, Senator. Senator Wilborn.
Present.
Thank you. Representative Finney. Chief Ackerman. Jennifer Basinger. Judge Brown.
Here.
Thanks, Judge. Sheriff Carr.
Here.
Sheriff. Judge Clark.
Here.
Thank you. Professor Francis.
Present.
Thank you. Chad Harmon.
Here.
Thank you. Spence Cohen.
Here.
Thank you. Tabitha Owen.
Here.
Thank you. Sylvia Penner noted that she'll be arriving a little bit later into our meeting. Bill Persinger.
Here.
Thank you. Professor Phillips.
Here.
Thanks. Pastor Robertson. Shelley Williams.
Here.
Thank you. General Schmidt.
I'm here.
Thank you. Executive Director Schultz.
Good afternoon. I'm here.
Thank you. Secretary Zmuda.
Randy Bowman is sitting in for the secretary.
Thank you, Randy. Connie Bonner. Believe I saw Connie on. I think she might be.
I'm here.
Thanks, Connie. Bob Gallimore with KLRD.
I'm here.
Thank you. Jordan Milholland, myself, I'm present. Malaysia Shagun.
I'm here.
Thank you. Jenna Moyer.
Yep, I am here as well.
Thanks. Natalie Scott.
I'm here.
Thanks, Natalie. Jason Thompson.
Here.
Thanks, Jason. I noted a few folks are here from CSG. Is Patrick here? I did see Greg as well, Greg Halls.
Yes, I'm here, and Patrick is now connecting to audio.
Thanks, Greg. I also saw Jennifer Casella with CSG.
Yes, thank you. Jennifer Casella, Deputy Program Director with the CSG Justice Center.
Thanks, Jennifer. Are there any other CSG folks that I've missed?
This is Sarah Wurzberg, also from CSG. Thank you.
Thanks, Sarah. Is there anyone else that I might have missed noting for our call?
Nope, you have all CSG staff.
All right, thanks, Greg. I'll turn it back over to Chairperson Bennett.
All right, thank you. So we have the meeting today, November 9th, and then we also have another meeting set for November 23rd. In going through the document, and I assume everybody got a copy of both the 8-page summary as well as, I think altogether 133 pages of attachments. There's an awful lot of information here, and my concern was that to give adequate time for discussion, trying to get all of the subcommittees resolved today would be probably more than we could accomplish, or at least with that giving adequate time for discussion. So the agenda everyone should have received shows we're going to go through the recommendations set forth by the data management subcommittee, which would be fairly modest. The diversion, especially court, especially prisons, supervision subcommittee, which will take quite a bit of time. And supervision working group as well. When you put all those together, that's quite a bit. And then with the mental health, substance abuse subcommittee, we'll finish up with their recommendations. And then we're going to discuss all of them. And the plan is, just so everybody, Jordan and I discussed this morning, the plan would be, just so we can all be on the same page here, is as we go through recommendations that are coming out of each subcommittee, I'm just going to number them 1 through however many we get. And then that way, number 1 later on is in discussions. When we get to number 12, number 13, we just take them up in order. Now, later on, when we're finalizing the report, they'll be broken down by subcommittee, but I'm just concerned that we get laborious to try to break down every, the top 3, the top 5 for this working group. For that work, we're just going to go 1 through until we're done. So that would mean that the proportionality sentencing subcommittee, the race and the criminal justice system subcommittee, and the reentry subcommittee we would give the full the November 23rd meeting to those 3 subcommittees. If I was overly pessimistic and we have a lot of time left over, we can take up one of those 3, but the plan is at least those 3 will devote the November 23rd meeting to those. So with that, the first thing up on the agenda is the data management subcommittee. I don't think we've only allowed a few minutes here for this because I don't think there's a lot of time required, but Sheriff Carr, I believe you are the current chair of that subcommittee. Is that correct?
Yes, this is Sheriff Carr.
Give the floor to you.
Thank you, Mr. Chairman. As you can all see in reading most all the other reports from the subcommittees and working groups, I think it's pretty clear, overstanding that we absolutely need an evaluation of our current systems across the state of Kansas when it comes to data systems, whether it be the merging or interfaces. But as we've witnessed just in the last few months, we currently have at least 2 state agencies that are rolling out new systems currently, which kind of goes against what we're trying to accomplish currently. So, I've reviewed most everybody's reports, preliminary reports for the final, and like I said, nothing that we didn't expect to see. But there's a portion of data management, records, information, and sharing within each report that everybody else has submitted. So pretty simple, just requesting legislation to take a long, hard, and serious look at least affording the commission an opportunity to go out for a review across the state. So.
Okay. I'm going to confess that I'm having for some reason, my connection, I guess you guys can hear me, but I'm on a scale of 1 to 10, my volume hearing people back is about a 0.5. So I'm going to try to get that rectified, but I want to make sure I heard what you said. We know we need more information about data systems across the state. Is there a specific recommendation legislatively, or do we just want to go back and ask again for a post-audit type of an approach?
I think the request is just an absolute post-audit of the systems in the state. Even
Okay.
with some of these working groups and subcommittees, I mean, there's some findings here that are preliminary, I guess, more or less assumptions of what we believe's out, but without a true data analytical dump, I mean, we just need a review.
We can discuss this later in the discussion session, but does anybody have any questions or anything before we move on to the next? Again, the plan is each subcommittee is going to lay out their proposals, and then we're going to discuss once we've heard at least the first 3 subcommittees' proposals. Any questions, any comments for Sheriff Carr? Hearing none, I'll jump ahead then. Thank you, Sheriff, to the next subcommittee, which is the Diversion, Specialty Court, Specialty Prisons, Supervision Subcommittee. The first one in order is Diversion Working Group, which oddly enough is mine. So I will go first here. In terms of the recommendations coming out of that working group, there's only one legislative proposal at this point. And since that's really the first, this becomes the first specific legislative proposal, at least in my notes. So we're all keeping on the same page here. I'm going to call this legislative proposal number 1. The post-audit request, or the request made by the data management subcommittee, isn't a specific legislative proposal, like a specific piece of legislation. So, but we'll kind of keep track of the post-audit, there may be other post-audit requests. But in terms of a specific piece of legislation, the Diversion Working Group wants to recommend that the Criminal Justice Reform Commission again endorse what we'll call last year's 2708, House Bill 2708. We'd ask that be reintroduced, and it would accomplish 2 primary goals, and that is identifying Senate Bill 123 money for diverted defendants, and also allowing, number 2, the ability for prosecutors, DAs, county attorneys to sign MOUs with their respective probation departments, whether that's court services or community corrections. I know there's some concern about that, and I think some of that'll be worked out in the legislation, but it's the same thing we talked about last year, and I think it was headed toward passage. 125 to nothing in the House. I have no reason to believe the Senate would have done different, but that's the first recommendation. So the number 1 legislative proposal is, we'll just call it the House Bill 2708, again from the 2020 session. In addition, there are 2 or 3 other discussion points that we wanted included in the Reform Commission's report, but they don't come with any specific legislative proposals. One is uniformity. There's a discussion, and it's really a public policy question about whether or not diversion should be required to be offered in each jurisdiction, and what, if so, there's some uniformity in terms of approach. We didn't really have come to a consensus on that, and frankly, there's some concerns about that, but it is a policy question that the legislature is going to have to address at some point. Maybe not this session with as much as is going on coming out of COVID, but that's one policy question. Number 2 is there some reason to believe that a less stringent diversion would be appropriate, something that would explicitly authorize pre-filing diversions? For instance, if I want to offer diversion to somebody without even filing a charge, could I do that? There are concerns about that, not the least of which has to do with memorializing what took place. How does the KBI or anyone else know what ended up with that arrest? Or there's records keeping that needs to go along with that. But right now, that's a concept that would be problematic under our existing law. And there's several attorney general's opinions that would cause concern, I think. So again, we're not recommending that something explicitly take place, but we are recognizing it's an issue, and the policy makers in Topeka need to at some point address how they'd like to address that concern. Number 3, the sealing of diversion. We had several comments from the public. One individual in particular asked that diversions be sealed. there's some, I understand the notion there, but again, we did not endorse that as a specific recommendation. There's a couple of other, again, public policy concerns there. One of them has to do with the fact that if someone's granted diversion, I still have some obligation to tell defendants that so if Smith gets a diversion, if we sealed that from public record entirely, and he's later a witness against Jones, I'd have an obligation to tell Jones that Smith had that prior diversion. And if we sealed it, it could be problematic. And so that's one of the concerns that was raised. And the other thing is, I think the same thing could be accomplished by the expungement statutes, which has already been modified once. You could not expunge a diversion in the past because it wasn't a conviction. That later was changed, I think in 15, I guess it was 98, it was longer ago than I remembered. So again, no legislative proposal, just a commentary. And then indigency, we want, if diversion is going to be expanded, and that's certainly one of the goals of this working group. And I think one of the goals of the Reform Commission, we don't want indigency to be a impediment to people being able to apply. And so the question is, as a public policy question, how do we make it available to people who can't afford to, make payments or apply for it? And the problem is a lot of because diversions are run on a county basis. It's hard for us to make a legislative proposal where we mandate that counties pay for it or that sort of thing, because that's again, unfunded mandates don't go very far typically in Topeka. So, but it's a question that needs to be addressed again by policymakers. So finally, I think number 5 was the last one. Deferred adjudications, it's come up. It's a different animal than a diversion. It is not allowed in Kansas. In fact, one of the criteria for deferred adjudication, which used elsewhere, is the person comes in and enters a plea of guilty to the crime they're accused of, and then basically the judge holds on to the adjudication and dismisses the case later if they're successful on their diverted program. And that's explicitly not allowed. Would be prohibited by Kansas law currently. And so this is not something we do here. It's something done in other states. And the question is it something we want to do? One of the things we found as we talked to others, I reached out to a friend in the AG's office in Oklahoma who confirmed, at least down there, what we believe to be the case, and that is that most states either have a diversion or a deferred adjudication. And so to completely scrap our diversion program in favor of a deferred adjudication, maybe that's something we want to take up someday. But right now, it's probably not anything we want to tackle in just one legislative session. So again, it's a public policy question, but we just wanted, in case someone asked, did anyone ever even consider that? Yes, we did. And the answer is we considered it, but do not have a recommendation that we endorse that as a state. But so took a few minutes there to talk about everything the working group covered. If anyone has any questions for me, let me know. Otherwise, I'll turn it over to the next group, but I'll stand for any questions. Sheriff Carr.
Yeah, this is Sheriff Carr. Mr. Chairman, I guess a question I have. So if they successfully complete the diversion with the plea, would that mean that it's not recorded as a conviction?
Correct. If it's a diversion, you're not convicted of the thing.
If they complete the diversion.
Correct. Yeah, if you are placed on diversion and mess up your diversion, and then we put you back on the docket and you're convicted, then it's just like any other conviction.
Okay, that's how I was reading. I just want to make sure.
Yep. Any other questions? Okay, I'll turn it over to the Specialty Courts Working Group. Judge Brown, I believe that is you.
Thank you. Attached to the report is proposed legislation, which is summarized quite well in the document we received for purposes of this hearing. So it's pretty self-explanatory. It sets up a committee to basically assist specialty courts, both those existing with funding for the future, as well as any judicial district that would intend to start a specialty court. That will provide the assistance in beginning that process, as well as hopefully in securing initial funds. As I said, it's pretty self-explanatory. I guess I would stand for any questions,
So since we got people who are maybe listening in, what specific are there a series of legislative proposals you'd want to, I guess, sort of read into the record here for us?
well, it's a package. It's one piece of legislation. It says it allows the Kansas Supreme Court to adopt rules for the establishment and operation of more specialty court programs in the state of Kansas. It sets up a specialty court funding advisory committee, which would operate under OJA. The committee members would be the chair of the House and the chair of the Senate Judiciary Committees, the chair of the Legislative Budget Committee, one member of the minority party appointed by the minority leader of the House of Representatives and minority leader of the Senate, 5 members appointed by the Chief Justice of the Kansas Supreme Court, a member appointed by the Secretary of Corrections, a member from the Department of Aging and Disability Services, a drug and alcohol addiction treatment provider appointed by the Kansas Sentencing Commission, all of those being ex officio that operate as advisors to the committee. The committee would attempt to secure federal grants, hopefully legislative funds to help, again, in the establishment and continued operation of specialty courts. It contains a provision that allows at the completion of a specialty court program, which, by the way, those are 18-month programs, same duration as the Senate Bill 123, that at the end of the program, if they successfully complete it, allows the judge to, at that time, expunge the conviction that cause them to go into drug court, or give the judge the option of reducing the overall probationary period that might have been imposed at the initial sentencing.
Okay, thank you. So that'll be, for everybody keeping track, that'll be legislative proposal number 2, as just referenced by Judge Brown's recitation. Any questions for the judge?
Chairman?
Bill Persinger.
Bill Persinger here in Topeka with Vallejo Behavioral Health. Thank you for your time. Judge, just a quick observation and or a question. You folks probably already visited this, and I don't know if it's too early to get into the area of cost, but and I'm a big supporter of specialty courts of all kinds, family courts and domestic violence, substance abuse, mental health courts, and the like. And of course, there is a cost on the part of the district court, and a lot of work to do there, which I'm sure you've considered. And also, generally, the individuals that are presented to these courts are also accompanied by third parties, mental health providers or others. So there's a cost on that end as well. And I'm not particularly stumping for funding, just want to make sure that we understand that to apply staff and resources to these courts there is a cost factor on both sides. So just wanted to put that out there. I figured you probably covered it, but wanted to put it out there. Thank you.
Thank you. Any other comments or questions for the judge?
Mr. Chairman, I would point out that this proposed legislation that's attached to your email has been approved by the Chief Justice of the Kansas Supreme Court. So we're hopeful that we may get the opportunity to present it in the current legislative or upcoming legislative session.
Very good. Okay, if no other questions, then we'll move on to the next working group within the larger subcommittee. I think that would be the Specialty Prisons Working Group. I'm trying to remember here off the top of my head. That's, I'm sorry, I'm blanking on who's in charge of that.
This is Spence going, and that would be General Schmidt, Mr. Chairman.
Hello.
General, you've got the floor.
Very good. Thank you, Mr. Chairman, and others. Our working group had 4 specific recommendations. They will sound familiar because they are the same 4 things we recommended last year and which the full commission approved and included in our interim report last December. So I'll cite them, but I won't dwell on them unless there's some reason to. First, we reiterated the recommendation to fully fund and provide authority for the Department of Corrections to repurpose an existing facility to become a new geriatric cognitive care facility with 200 to 250 male beds. That recommendation was included last year in the governor's budget submission. It was approved and funded by the legislature. And it is my understanding, unless Randy or somebody else at DOC tells me otherwise, that that project is proceeding apace. So I don't think there's any further action by us required for advocacy. We just reiterate that we continue to think it's a good idea and would like to see it followed through. Second recommendation was to fully fund and provide authority for DOC to repurpose a different existing building to provide a new 200 to 250 male beds specifically for substance abuse treatment. That recommendation also was included last year in the governor's budget submission. It also was funded, the money was appropriated and the authority provided by the legislature before they departed early in the spring due to COVID. There had been some disruption in that over the course of the summer, and I won't characterize it because I honestly don't know the current status. The issue was basically when the bottom fell out economically and the state budget collapsed. There was caution advised in terms of proceeding. So I'm not entirely certain the status on that, but our recommendation is if it's happening, it should, and if it's not, it still should. We ought to do that. Same recommendation as last year. The third recommendation is very similar to number two. It is essentially add additional capacity for additional substance abuse treatment beds within the DOC system. The concept there was a greenfield facility, probably one would assume located geographically remotely from where the first one is, so you don't have all the beds in one place. That's a much more expensive option. It was not included in the governor's budget last year, therefore wasn't considered by the legislature. But we renew our recommendation, just as we did last year, that it also be authorized and funded. And the commission will remember the concept on both of those substance abuse facilities were, among other things, to provide an actual facility, which has never existed, to give effect to the special sentencing provisions that were adopted in substantive law by the legislature after the 3 R's Commission that are still on the books. Not that they're the end all be all, they're more than a decade old now, but they've never been tried. And so that was part of the reasoning going down that road. And then the fourth and final recommendation was simply to endorse the recommendations of the Mental Health Task Force. And while there are several of those recommendations, and anybody can look them up or read them, really at their core, they're about adding beds that actually function and are staffed at both Larned and Osawatomie. So, Mr. Chairman, those are our 4 recommendations. They should be familiar, and I'd be glad to either stand for questions or proceed otherwise.
Okay, any questions for the general?
This is Sheriff Carr. I've just got a comment. I think it should be noted that all of those are critical to the rehabilitation and reduction of recidivism in Kansas.
Say that one more time, I'm sorry.
I just believe it should be noted that all of those recommendations are critical to the rehabilitation and reduction of recidivism.
Yep, very good. So General, again, I apologize. I'm working on the IT end of my side here to make sure I heard everything, but your 4th recommendation of 4 is really to endorse the Mental Health Task Force. So in terms of, if we're kind of keeping track here of specific legislative proposals, the number 2 being the package legislation Judge Brown just mentioned, and you've got your first 3. Those are the ones with, I think, more specific legislation attached to them. Is that correct?
Mr. Chairman, yes, it is. I would just say really all 4 of these recommendations are funding recommendations. I mean, you need authority perhaps for number 3. There may be some authority, substantive law authority needed for number 4, but really at the end of the day, they all boil down to money to create capacity to allow services to be delivered and avoid the binary choice of in a prison, a traditional prison, or on the street. That's really what they boil down to.
Well, that's a good point. I think really, I mean, maybe it's a false distinction to talk about specific legislative proposals as opposed to just a specific recommendation. So you got 4 recommendations. I think we'll just list them as all 4 and go from there. So very good. Any other questions for the general? Okay, we will move on to supervision working group. Shelley Williams.
Thank you, Mr. Chairman. Shelley Williams, Riley County Community Corrections. The supervision related legislative initiatives are as follows. We are recommending to adopt the Kansas Association of Court Service Officers legislative initiative to amend KSA 8246. And that would enable court services and community corrections officers to be able to provide a certificate of ID. Right now in the state, parole has the ability to issue those. And unless you are in close proximity to your parole office, you don't have that ability to access that. And so this really enables offenders to be able to get IDs, which leads to employment, among other things. And so instead of duplicating that effort, we decided to support the Kansas Association of Court Services Officers initiative. The second supervision-related legislative initiative would be to adopt the Kansas Sentencing Commission's legislative initiative in support of earned compliance and the strengthening of early discharge mechanisms for people on supervision. That is something that the Sentencing Commission took up at their previous meeting and are continuing to discuss and bring forth legislative recommendations. The third is to support the creation of a work group to examine policy to consolidate concurrent supervision cases. There's approximately I skipped one. Standardized conditions of supervision. Support the creation of a work group to create standardized conditions of supervision. In our assessment and with the work of the Council of State Governments, what we discovered was that standardized conditions of supervision varied across the state in the number, the type, the length, and the complexity. One jurisdiction having as many as 55 different conditions of probation, with the average ranging between 15 and 25. The fourth would be to support the creation of a work group to examine policy to consolidate concurrent supervision cases. What we discovered was that approximately 1,200 offenders are on dual supervision between community corrections agencies and parole. And what this really does is it creates duplicative appointments, duplicative assessments, duplicative drug tests, duplicative drug testing fees, duplicative supervision fees, sanctions, and ultimately what that creates is conflicting conditions for the individual, which creates a net widening of violations and possible revocation hearings. As is noted in the report, 58% of prison admissions in FY19 were the result of condition violations and sanctions. And that cost the state $43 million to incarcerate those people who were violated and sent to prison. The next recommendation is to support the formalization of KDOC's approach to parole supervision violations, including implementation of effective responses to behavior. And that is something they are currently engaging in. Mr. Chairman, would you like for me to go on with recommendations that are outside the legislative recommendations? He disappeared. I will go on. In addition to those legislative recommendations, the following recommendations for the Reform Commission, if it is extended, or another work group to develop an interagency re-engagement unit. That would be for those absconders that are currently existing in the state, which is roughly approximately 20 to 25 community corrections clients are on absconder identification. Formalize interagency collaboration between the 3 supervision entities and support interagency collaboration. And really what these two speak to is the sharing of resources, the sharing of expertise, what we discovered is that programming is scarce across the state, but it is also extremely varied amongst the 3 different supervision entities as far as what is available between parole, community corrections, and court services. And then formalize the use of effective responses to behavior. The Department of Corrections is currently rolling out the use of a 4-to-1 behavioral management program, where there will be a database accessible to supervision officers, both in parole and community corrections, that will be able to access in how they dole out their responses to behavior, both incentives and sanctions. And then the following topics we felt like needed to be studied further, which was really to ensure that the statewide availability of robust sanctions and incentives. And of course, data integration to merge siloed data, and then really work on strengthening the mission vision statements of all the supervision entities, whether that be at the state level or at the local level, so that there is more uniformity in our approach with how we supervise offenders in the state. So with that quick summary of 20 meetings of work, I would stand for questions.
Just so I'm clear here, I've got my IT problem fixed, hopefully. I've got, and I missed one thing. I got 4 specific policy recommendations, or was there a 5th?
There was a 5th.
And I'm sorry, what?
No, you're fine. Support the formalization of Kansas Department of Corrections approach to provide supervision violations, including implemented effective responses to behavior, which is that 4-to-1 behavior management program. Which
thank you. I was switching from one computer to the next and just missed that. I apologize. So I'm in better shape. All right. Anybody have any questions for Shelley?
I have a question, Mr. Chairman. Representative Stephen Owen. Shelley,
yes.
On number 2 of your legislative proposals that refers to 2019 House Bill 2052, is that the, I'm trying to remember my bills here, is that the bill where the Sentencing Commission requests or suggested a 50% good time credit instead of the current 10 or 20%?
So that is a great question, and thank you for asking that. And I might ask Scott with the Sentencing Commission to help me out. There were 2 different proposals that came before the Sentencing Commission just this spring, but that definitely, the 2019 House Bill 2052 represents a 50% review hearing to be scheduled for after the point of supervision. There was another piece of that was discussed at the last meeting, which included 7 days off of supervision for every 30 days of compliance, substantial compliance. I know we voted on the substantial compliance definition, but I'm not sure if we finalized which or if both proposals we were going to embrace for this next session. If Scott's on and has a little bit more information, that would be great.
Sure, Shelley. Scott Schultz with the Sentencing Commission. We did, Representative Owens, that was a separate bill that the commission plans to bring forward as far as good time credits. This is this specific provision that this subcommittee is recommending is part of the commission's request to, as well as this subcommittee, we wholeheartedly agree that incentivizing offenders on probation, just like we do in the incarcerated population, is a great idea. And this one in particular doesn't deal with good time credits. It deals with what Shelley was talking about. 2052 had to do with at the time the court would be required to set a hearing at the 50% mark of probation, and the individual could, if they complied with the terms and conditions of their supervision and they are in substantial compliance with those terms of supervision, they would potentially be eligible for modification of their probation or completion or termination of their probation. We also, that extra provision that Shelley spoke of, you would get 7 days credit for each month of compliance. And again, both provisions are aimed at incentivizing the offenders to specifically allow them to understand just exactly what they need to do to get off probation early. And if they can do that, some of those things that we discussed had to do with folks that are on, as you know, we have 12-month supervisions, 24-month, 36 months. Some are up to 60 months of supervision. Those obviously would potentially be cut in half. Likely the ones on 12-month supervision won't, just simply because we've crafted a definition as far as substantial compliance is concerned that would require them to complete any program that would be required of them on supervision. So if they were in the midst of substance abuse or mental health treatment and they had not completed their program yet, they would not be in substantial compliance. So it gives those offenders opportunities that if they are compliant, they do finish their programming, to get off of probation, but it still holds their feet to the fire as far as making sure they get the programming that they need based upon the risk and needs of the offender.
And a follow-up question, again, Representative Owen Scott, is that one where it still leaves it up to the judge's discretion as to whether to shorten that term, or is it an expected, if they're in substantial compliance, their probation's automatically cut in half?
The current language is that the court would be required to grant the discharge unless there's clear and convincing evidence that it wouldn't serve community safety interests. So that hearing would be set. There are several jurisdictions in the state that already use this informally. And if there are things like, for example, an individual has an outstanding warrant against them, or there are some other issues, they don't have the hearing that has been set up. But the offender knows then at sentencing that they're going to have a hearing set halfway through their probation. And, it becomes an issue of if they aren't complying, then there really isn't. But there gives an opportunity for all parties then to come together. And if there is an issue, prosecutors then can make that argument that the individuals needs to stay on probation if need be.
Excellent. Thank you very much for that explanation, both of you.
Any other questions for Scott or Shelley? Sheriff, did I see you, Sheriff Carr?
Yes, this is Sheriff Carr. So just verifying. So the initiative in this is geared towards a change in conduct, correct?
Correct. To incentivize behavior, to motivate them to actually change their behavior.
Thank you.
I know we're going to have discussion about all of these recommendations here at the end of the meeting today as we go through them all and open them back up for more questions and a vote and make sure we endorse or don't various recommendations. I will point out one thing there that I think has been maybe exposed by COVID, and that is if we add a hearing for everybody placed on probation at the 50% mark of their probation, after if they've been on probation for, they're given a 12-month, if we have to have hearings after 6 months for everybody, that's going to add a lot of hearings. And so I can see I understand why that'd be a good thing. At the same time, I'm just trying to manage in my own mind right now when we've got so little ability to have substantive hearings during this time. I don't know. I'm just thinking out loud, but more discussion later about that. Anything else for Shelley or Scott? If not, we will move on to, okay, I guess first of all, Spence Cohen, I'll ask you, is there anything else? I think we covered all of the subcommittee, the diversion, specialty court, specialty prisons, supervision subcommittee. It's the least easy to say subcommittee of all of them. But is there anything else that we didn't cover from any of those working groups? Anything else from your subcommittee you wanted to put in front of the commission?
This is Spence Cohen with Office of Judicial Administration, and I think that covered everything as I went through. Those were all of the recommendations that were made.
Okay, very good. Well, then I'll turn to Representative Owens, the Mental Health Substance Abuse subcommittee, excuse me. You're up next, and we are actually doing very well. So in terms of time, this will give us quite a bit of time to discuss all of these. We're going to go back through these and make sure we're going to take a vote. But so just making a comment that we're doing well on time. Steve, I'll turn it over to you.
All right, bear with me for just a second while I scroll down to our report. First of all, I want to make note that that when I submitted this report, I failed to add all of the members of the subcommittee, so I will make sure that that gets added to this. My apologies for doing that. Let's see, get on down here. All right, so first and foremost, our first subcommittee recommendation sounds very similar to what Chairman Bennett recommended, and that was the reintroduction of what was previously House Bill 2708. You will notice that this is the same legislation that was suggested by 3 different subcommittees in our interim committee report. I did point out, however, that when we worked through this and got this introduced, it did make it through the House on 125-0 vote, which really is phenomenal for it to go that far. Sadly, it died in the Senate due to the shortened session, but that I already have on my list to have our reviser Natalie reintroduce so that we can hopefully get a good jump start on that. We also made a few statements through here. So this is one of our legislative priorities here. We talked specifically about just access to treatment being something that needs to continually be on the minds of legislators as we look at budget issues, as we look at where we could be most effective with the use of funds. We also had the Council of State Governments and their recommendations. I won't rehash every one of those. If you guys will recall, we went through all of those already at one time and had their presentation. So we adopted each of their recommendations, and we're again grateful for the work and the recommendations that they proposed. Currently, let's see, number 4, currently first and second possessions of marijuana charges are misdemeanors. Subcommittee recommends the legislature amend the severity level of all personal use drug possession charges from a felony to a misdemeanor similar to marijuana. Long-term challenge of having felony record include housing and employment issues. The focus of this specifically, and this is one that certainly warrants conversation and input from all parties, is the idea that treatment has got to be the focus. We have got to put people in a position to receive the treatment that they need, especially when we know the bulk of property crimes are addiction-related items. So that is a recommendation that is certainly one that I want to hear everybody's opinion on. But our committee and Professor John Francis, he's the one that made this recommendation, and after talking through it thoroughly, seemed like it really makes sense to ensure that. So let's see. The co-responder system, again, we've seen the effectiveness of a co-responder system in Sedgwick County on a limited scale, but especially in Shawnee County and other areas. And it's our recommendation that the legislature figure out a way and a mechanism by which to fund more of a permanent co-responder system. Again, the idea is to get mental health workers or mental health treatment to those that need it instead of the de facto putting them in jail in the mental health pod. So co-responder system is one of our recommendations. There were a number of specific programs that we wanted to raise the attention of the legislature as it relates to programs, prevention programs that focus on gainful employment and positive family and social relationships. The sequential intercept model is a model that can be a framework for community-based services and collaborations needed to divert the justice-involved individuals. So again, policy consideration on the sequential intercept model. Another recommendation from our committee that, again, we recognize there are some significant, we recognize with many of these, there are significant financial hurdles, but as a subcommittee, we made the decision to not let funding stand in the way of our recommendations, that these needed to be put out there and they needed to be talked about so that as funding becomes available, these good ideas can be put into practice. Recommendation number 8 creates a behavioral health liaison and a corrections liaison. One of the biggest challenges that we see within the criminal justice system as it relates to mental health and substance abuse is the lack of collaboration between our CMHCs and our substance use facilities to ensure continuation of care once they're released from the facility. And creating these liaison positions, again, scaled to fit certain organizations, scaled to fit certain size counties, would certainly allow there to be somebody in that jail that is focusing on continuation of care, especially for mental health as they leave. And then, you know, somebody on the CMHC side of things that's ready to receive that information and follow up with these people. So a couple of liaison positions. We also added a piece in there, should be consideration given to the use of a peer support services. We kind of lumped it in here because it seemed to fit with this continuation of care model. But Harvey County has a great peer support model through our community chaplain response group, where these are people that have been through the system, they've been through addiction issues or mental health issues, and they've come out on the other side, and they can provide some significant peer support services and do so in this area. And so the expansion of programs such as that. Expanded access to detox and evidence-based treatment. That's an ongoing recommendation that I think we're going to have to continue to push and to drive because many areas in our state, rural frontier areas, they just don't have this access. Some of our bigger cities do, but even then they certainly can use expansion. We wanted to touch on specialty courts because we recognize the importance of them and just put in here that you know, these courts have shown to produce better outcomes for those involved. This committee fully supports the use of specialty courts within the criminal justice system. So we knew that there was a subcommittee, didn't want to spend a lot of time on that other than to recognize that those specialty courts play into mental health, substance abuse related items, and that they should receive the support of the Criminal Justice Commission here. On-site, again, consideration should be given to the establishment of on-site behavioral health services, such as counseling, peer support, psychiatric medication prescribing, discharge planning. Again, falls back into that liaison conversation, but things, again, one of the big challenges that we run into is, you know, we have these people, they end up in our system, they might receive the medication that they need while they're in jail. But as soon as they get out of jail, they're given a 5-day supply and say, good luck. There's no continuation of services there. And that's something that we as a subcommittee believe we need to focus on. We also referenced studies of cost avoidance, such as those produced out of Wichita State University and decision-making plans. There was a great cost avoidance study done in Sedgwick County that talked about the value of the co-responder model and a number of other systems. And, you know, we put that in there specifically because that is really a good selling point to the legislature, right? When you can show that because we invested in this, we saved this amount, there's a lot of value in those cost avoidance studies. So it's something that should be considered when we're looking at alternative treatments versus incarceration, is making sure that you know, when able, we can get the cost avoidance study. Let's see. As you can tell, we have a number of recommendations, so I'm just going to keep going and I'll take some questions here at the end. 13, a major driver of high incidence of mental illness in jails and correctional systems is the lack of access to acute care in psychiatric hospitals and residential programs created by the Medicaid Institutions of Mental Disease Exclusion, which prohibits federal reimbursement for care provided to most patients between the ages of 21 and 64 in mental health facilities with more than 16 beds. Consideration should be given to applying for a waiver from CMS for reimbursement of mental health services in residential psychiatric facility and treatment centers. This could create a pathway for the expansion of certain community-based programs that could be alternatives to jail times, such as residential programs, transitional living programs, so forth, as well as expand access to the services. So there is a specific issue there that restricts the size of beds, and that's something that we as a state should consider looking at a waiver for, to possibly be able to expand that, and that would open up more beds and more opportunity for mental health. One of the big bottlenecks in the court system is the ability to get the competency evaluation restoration services to the courts. It was brought to our attention brought to my attention specifically in Harvey County that to get somebody sent to Larned for a competency evaluation is a 6 to 9 month wait. I was told 6 months. I hear it's up to 9 months now. So we recommend the support of trained mobile competency evaluation and restoration providers. So the ability to, whether that is done through the CMHC or that is independent under KDADS or what that looks like. I know KDADS is working on this as well, but we have got to be able to move people through the system faster and ensure that they are competent to stand trial, or that they're not, and the appropriate action taken to ensure not only speedy trial type of situations, but simply for a bottleneck that currently exists in the system. And it's a huge issue, I know, in my area, and I'm sure it is in nearly all areas. So carrying on with that, of course, overarching all of this is workforce retention and recruitment. Continues to be a huge challenge within both the mental health and substance abuse fields, especially in rural and frontier areas of the state, where it is not uncommon for a counselor or psychiatry position to remain open for months or years. It's imperative that the emphasis be placed on workforce development in these areas by the Kansas Legislature. So whether that is, through some kind of CTE program or how we can do that, that will leave open, but workforce recruitment has to be a primary focus in ensuring that we have the adequate number of people to help us do the things that we need to do and these recommendations that the subcommittee is making. So with that in mind, a lot of recommendations, a lot of information. I will stand for questions.
Questions for Representative Owens this time? Okay. Oh, Sheriff Carr.
Yeah, this is Sheriff Carr. Representative Owens, thank you very much. I know that as a member representing the Kansas Sheriff's Association, mental health is obviously an issue at the local level. It's extremely critical that it's addressed. Some of the concerns we have at the local level, obviously the expense. I'm glad that you did in one of your bullets support statewide implementation of funding of a co-responder program. I think to expand on that, the state funding is essential, but it's also essential for the liaison position. The CMHC centers, there's an expense to as well. The on-site behavioral health services in the jail, there again, rural parts of the state, safe to say that we would all like to have those services in our facilities, but we're back to having staff available, the professionals from the mental health field. That is something that we're lacking in the western part of the state. And again, I think a lot of that being on the mental health board out here, it's hard to employ somebody just for our facilities out here just due to pay. On occasions we get somebody hired and then they turn around and leave just a few months later. So critical points, I think that should be noted. And then, in response to the competency evaluation cases, we've got one here. You're talking 6 to 9 months. I've got a inmate here that's been waiting since December of 2019. So we're several months out. And again, so it's not that I want them in my facility, but I can't get them into Larned or Osawatomie to get the services they need to finish their court cases. So, and then on one separate note, a concern that the Sheriff's Association has is on your bullet talking about the severity level of all personal use drug possession charges from felony to misdemeanor. It seems to be a slippery slope when you're talking about meth, cocaine, heroin, and of the sort. So that is one area that at least the sheriffs have one concern with, but everything else we seem pretty happy with.
Oh, thank you for that, Sheriff. And I know funding is it's the challenge with all of these, right? Anything to do with mental health and substance abuse. And I think we're starting to take some steps that direction, right? Last year with the diversion program and setting aside funds for the implementation of substance abuse treatment for diverted inmates or diverted defendants was a huge step in the right direction that had full support of the legislature, which came with a substantial price tag. I think that those are there. I'm also very, trying to think of the right way to put it, very optimistic at our fiscal outlook for the state. As you guys may have heard as recently as last week, we went from a $1.4 billion projected budget deficit to around $200 million. So our state is back on track, economically looking much better than was projected just 6 months ago. So I'm optimistic that we can continue to drive in that direction, and we hope that we continue to see stronger finances coming into the state to push some of these issues. But that's where those cost avoidance studies come in, because it's really clear when I can show somebody that if you invest $1 million now, you're going to save 10 million over the next, 5 years or whatever. That to me is what sells it to a guy like myself, right? I like to look at what's the long-term investment, the long-term return on that investment. So keeping that in mind. Also recruitment, we've tried various different ways as it relates to aircraft workers, as it relates to technical trades, integrating that into our high schools, the CTE programs, putting specific emphasis on substance use treatment and mental health treatment people will hopefully drum up some suggestions or some ways that we can incentivize people to get into those career fields as well. Of course, our overarching problem is the fact that we lose more of our young and bright folks every year than we retain in the state because they graduate college and they go elsewhere, or they graduate high school and they leave the state. And so that's a trend that we have to change on an overall scale. But then, incentivizing some people to get into these fields would certainly be beneficial. And finally, I totally understand the sheriff's concern. Look forward to really having that conversation about where that balance should be. The overarching thought when it comes to, for example, a possession of meth charge, if that is all that you are charged with as a possession of methamphetamine, does it make sense to permanently brand somebody's record with a felony over an addiction issue? And that's where our conversation lies, is does the punishment fit the crime? The long-term punishment of, okay, you made a stupid choice, you got hooked on meth, now you have a felony, now it's next to impossible to get a job, it's next to impossible to get housing, just so many other challenges created by that. And how do we change that so that people have the opportunity to seek treatment, to turn their life around before they actually get branded with that felony, because you and everybody else understand the impact of having a felony record. So that's where our logic lies with that. And so I certainly look forward to conversations with the Sheriff's Department on that.
Any other questions for Representative Owens? Spence, did you have something?
Just a couple notes. Again, and this kind of goes along with what Sheriff Carr just mentioned, but fiscally, of course, Representative Owens, understand 100% about the drug case, dealing with those for the last 25 years as a probation officer. There would, of course, like you've already mentioned, though, be a significant financial impact, specifically with court services. I just know in my experience as a line officer over the last 2 years on the number of pre-sentence investigations I wrote for possession of meth and such, that the court services would take a lot more cases, and so that would need to be addressed. As far as the mental health, and this again, what Sheriff Carr just talked about, the pretrial justice task force just released a report earlier this week that aligns a lot with what both of you spoke of, that with KDADS issuing, it's specifically having more regulations for the Crisis Intervention Act so that more centers could be licensed, as well as provide adequate funding for LARNet. So I know that those really align with what you just said. So I just wanted to bring those points up.
That's great. Thank you, Spence. I appreciate that.
Okay. Anything else? All right. Lots of faces, but I don't see anybody waving or throwing up any confetti, so I'll assume we can keep going here. On our agenda, we are clipping right along here, and in fact, we're about 30 minutes ahead of pace. At 2:30, I was going to give us a 10-minute break. We're 5 minutes past that, so when we take a break till 2:45, and what we plan to do is come back now and start going through these specific recommendations. And I think the way we did it last year, which I think was effective, and I'm certainly willing to take any suggestions to the contrary, but come back and open these back up for discussion, and I'd like to take a vote. I want to know if we're going to endorse something explicitly with the imprimatur of the commission. I'd like to know what our vote is. So, and some of these are going to be just included in the final report. I mean, for instance, the working group on diversion. There's only one real recommendation that we want to put forth as a substantive ask. But there are 3 or 4 or 5 other things that we want in the report so that legislators can look at it and when the time comes in future sessions, maybe take some of these things out. But that would be my plan. So when we take 10 minutes, we'll come back here at, like I said, 2:45 and start going back through these and taking some votes. Okay. See you all in 10. All right, we'll give everybody about 30 seconds to find their chairs and get back on. All right. See, people are joining us again. So most of you have got the, you can see this, but the 8-page memo that Jordan and Bob put together, and try to follow that as well as making some notes here. Unfortunately, this is the upside with Zoom is it saved a lot of us a lot of driving, and this is a handy way to get together. But I believe, and Natalie or General Schmidt, not to put you on the spot, but I think the only way we can, since this is a vote to put something specific to the legislature, I think the only way for us to vote effectively is to do so with a roll call vote as opposed to just show of hands. It would not be easier and faster, but Natalie or somebody from the Attorney General's office, if you disagree, I'm all ears, but I think that's the posture we're in. Natalie?
Thank you, Chairman Bennett. This is Natalie from the Revisor's Office, and Attorney General Schmidt can weigh in as well. I think that's definitely the safest way to do it, is to do a roll call. I think then it's very clear who the whether the motion passed or failed. So that's what I would recommend doing as well.
General, I saw some nodding back there. Okay.
I agree.
Very good. Just to try to save a little bit of time, since we have, I believe, at this point, 21 recommendations, we'll see if there's everything there's some degree of consensus on. For instance, on the specialty prisons working group, there are I think 4 things here specifically. If there's something we have some consternation about, we can pull one out, but then I can do a mass vote on the remaining 3, see if we have approval, and then we can go back and talk about the one. That way, we'll at least make better use of our time. So with that caveat, we will start with the Data Management Subcommittee. The issue that Sheriff Carr proposed is we need to make another proposal for comprehensive assessment. It's not a specific legislative proposal, but it is a specific recommendation coming out of that subcommittee that the legislature as policymakers needs to take some affirmative step toward doing a top to bottom assessment of the data management systems across the criminal justice system. Sheriff, have I framed your issue appropriately? Seeing a nodding of the head there. So let's open this up for discussion. At some point, what we'll do is take a motion. Do we as a group want to endorse this as a specific recommendation to be included? Or I guess, let's put it this way, unless somebody comes up with a reason to excise something from inclusion entirely, even if it's something we all don't come to a consensus on, it's still going to be included in the subcommittee's report. It's still going to be in the public record, still going to be there for the legislature. But I'm making that distinction as opposed to we want to affirmatively ask the legislature to address this. So what discussion, what concerns do we have as to this subcommittee's first recommendation? Okay, well, I'll construe silence as acquiescence or consensus here. So do we have a motion that we want to endorse this as a specific recommendation to be given to the legislature?
Mr. Chairman, this is Jean Phillips from KU. I so move that we endorse this.
Okay, Professor Phillips has a motion. Do we have a second?
Second. Chairman, Bill Persinger and Topeka. I'll defer to the representative.
Gail Finney was our second, I believe. Is that correct, Gail? Yes. All right. So Representative Finney has seconded that motion. So Jordan, I will turn it over to you to do a roll call vote on that motion that we endorse the Data Management Subcommittee's recommendation. And my vote, I think I'm first up, is aye.
Thank you, Mr. Chair. Jordan Milholland, KLRD. I'll go ahead and continue with our roll call vote. Chairperson Bennett voted aye. Representative Owens,
Aye.
Senator Haley,
Aye.
Senator Wilborn,
Aye.
thank you, Senator. Representative Finney,
Aye.
Chief Ackerman,
Aye.
Jennifer Basinger, Judge Brown,
Aye.
Sheriff Carr,
Aye.
Judge Clark,
Aye.
Professor Francis,
Aye.
Chad Harmon,
Aye.
Spence Cohen,
Aye.
Tabitha Owen,
Aye.
Sylvia Pinner,
Aye.
Bill Persinger,
Aye.
Professor Phillips,
Aye.
Pastor Roberson, Shelley Williams,
Aye.
Hey, Jordan, I'm going to stop you right there. Pastor Roberson, I think you were on mute. Did you vote aye?
Yes.
Okay, there we go. I'm
Thanks,
sorry.
Mark.
Yep. Everybody? Jordan, is that it? Just for the record, is that everybody, Jordan?
Oh, sure. Yes. Sorry. Yeah, I completed the list of our votes.
Okay, very good. Okay, one down. We'll move on to the long named subcommittee, Diversion Specialty Court, Specialty Prisons Supervision Subcommittee. First up was the Diversion Working Group. That's the one I discussed, and that is the recommendation that we endorse what was House Bill 2708. It may be a different bill number this year, but it has to do with the expansion of diversion. There are several other recommendations, but none that require any specific action be taken. They're just policy questions that we think the legislature should be aware of and should, in their own time, be addressed. So do we have a motion to endorse the first recommendation from the Diversion Working Group, that being reintroducing House Bill 2708?
So moved.
I got Shelley Williams as the movement, and I think, was that Representative Owens? I'll take that as a second from you then.
That will work.
You know, I'm going to, at risk of complicating things here, we've also got the Specialty Courts Working Group. Let's open that up while we're discussing things, because one thing we could do is just take up both at the same time here. I don't know. That's probably a bad idea. I'm just thinking of trying to shorten this up. Sometimes the only way to do it is just to do the damn thing. So Jordan, go ahead and call a roll on the Diversion Working Group's recommendation.
Thank you, Mr. Chairperson. Again, Jordan Milholland with KLRD. This is a vote on the motion to endorse the recommendation regarding HB 2708 by the Diversion Working Group.
Pardon me, point of order, please. Jordan, Mr. Chair, this is David Haley. Is it possible or it's not to do a voice vote and or must it be a roll call?
Thanks, Senator Haley. I defer to the revisers or the Attorney General on the question of this.
Mr. Chairman, this is Natalie from the revisor's office. Senator Haley, I think we kind of talked about this before. Chairman Bennett indicated that he thought that it would be best practice for us to do a roll call vote for each of the votes. And then I indicated that I do agree with that method, and Attorney General Schmidt seems to agree with that method as well. So if the chair wants to do it differently, we can talk about that, but I believe that's the chair's pleasure at this time.
Yeah, I think I'd prefer to do a voice vote, but at the same time, if we're going to do this right, let's do it right. So it takes an extra minute. But,
thank you. Thank you.
So I'm first up on this one. Vote aye.
Thanks, Chair Bennett. Representative Owens,
Aye.
Senator Haley,
Aye.
Senator Wilborn,
Aye.
Representative Finney,
Aye.
Chief Ackerman,
Aye.
Judge Brown,
Aye.
Sheriff Carr,
Aye.
Judge Clark,
Aye.
Professor Francis,
Aye.
Chad Harmon,
Aye.
Spence Cohen,
Aye.
Tabitha Owen,
Aye.
Sylvia Penner,
Aye.
Bill Persinger,
Aye.
Professor Phillips,
Aye.
Pastor Roberson,
Aye.
Shelley Williams.
Aye.
Chairperson Bennett, that concludes our roll call list.
Okay, Specialty Courts Working Group, that was Judge Brown's group. He gave a quick recitation of the multifaceted comprehensive plan that was put forth. And I should also say the plan that's already been endorsed by the Supreme Court of the state of Kansas, which I think should carry some weight. What discussion is there? What questions do we have of Judge Brown regarding the comprehensive proposal put forth by that Specialty Courts Working Group? Okay, again, silence is good. That means everybody's on the, either holding their thoughts to themselves or we're all on the same page. So we'll go through this one more time. Jordan, I'm first up. First of all, excuse me, we need a motion. Do we have a motion to endorse the recommendation put forth by the Specialty Courts Working Group? Number one, do we have a motion?
So moved. Bill Persinger and Speaker.
Persinger, do I have a second?
Haley, second.
Senator Haley from Kansas City is our second. So with that, with no further discussion, Jordan, the first vote, Mark Bennett, chair, aye.
Thank you, Mr. Chair. Jordan Milholland, KLRD. I'll continue with the roll call. Next up is Representative Owens.
Aye.
Senator Haley.
Aye.
Senator Wilborn.
Aye.
Representative Finney.
Aye.
Chief Ackerman.
Aye.
Jennifer Basinger. Judge Brown.
Aye.
Sheriff Carr.
Aye.
Judge Clark.
Aye.
Professor Francis. Chad Harmon.
Aye.
Spence Cohen.
Aye.
Tabitha Owen.
Aye.
Sylvia Penner.
Aye.
Bill Persinger.
Aye.
Professor Phillips.
Aye.
Pastor Roberson.
Aye.
Shelley Williams.
Aye.
Are there any other members I've skipped over? Okay, I believe that concludes our list, Chairperson Bennett.
Thank you. All right. On the Specialty Prisons Working Group, we've got by my count, 4 proposals here. My plan would be is if we have consensus as to all 4, we'll just put them as a package motion and move to endorse the whole thing. If not, we'll pull out anything that we need to discuss and at least try to eliminate the need for 4 separate roll call votes. I'll turn it over to General Schmidt for any questions folks might have. But again, to just summarize for all of us and also for anybody listening. And again, I should clarify, if somebody joined this late, we're not just blowing through these. We've got a 133 pages worth of reports already prepared and submitted to all of us ahead of time. So we've all had a chance to review these. But the 4 proposals here is set forth in the summary. Is authorized funding. We're going to ask the legislature to authorize funding and authority for a substance abuse treatment center within the correctional facility, within KDOC, and give effect to statutory provisions that were adopted as part of the 3R committee, which I believe was a 2006 effort, if I'm not mistaken, as to the time. Funding and authority to build a substance abuse treatment center to provide an additional 240 male beds for treatment, and funding and authority to allow the DOC to continue repurposing and renovating an existing building to provide 200 to 250 male beds for treatment. That was the first proposal. I guess I'll just do this one at a time. What discussion points do we have? What questions do we have for General Schmidt as to that first proposal from the Specialty Prisons Working Group? I guess I'll have just one. Derek, do we have, do we want to get, is it just a general request for finding a funding stream, or is there any more specific request with regard to where money would be found? You know, anything specific with regard to the funding source?
Yeah, Mark, nothing specific on the funding source. The funding amount is attached to each recommendation, each of the first three recommendations.
Very good.
Chairman Bennett, Representative Owens, if I might just recognize that this was similar to what actually passed in the budget last year. So the funding was there. It was pulled. A number of those specific items, the geriatric care and the substance abuse care, were cuts that were made as a result of budget shortfalls due to the pandemic. So I'm relatively confident that those will be put back into the budget and supported. So just wanted everybody to be aware that they were once already approved in the budget, but were pulled back out.
Okay, very good. Very good. So number two.
Chairman Bennett, can I
yes.
ask a quick question? This is Jean Phillips from KU. I'm wondering if there was any consideration, and maybe I should have asked this when we were first talking about this, about having substance abuse beds for women. These are all male beds. Was there any consideration, considering the number of women that are, the increasing number that are being incarcerated for drug abuse issues? Just curious if that was on the table at one point.
Yeah, Gene, this is Derek, and some of us did talk about that. Ultimately, when the package got put together, you know, what was this, a year and a half ago, I guess, almost year and a quarter ago, last fall, we deferred to KDOC on what they wanted, and this is what they had.
Thank you.
I'm sure when the discussion comes up in the legislature, there'll be some questions about, you know, sort of a phased in approach, and maybe that being phase two. My guess is they were simply going for the biggest bang for the buck right now. You probably more cost benefit with male beds at the moment, but you raise a good point. Any other discussion about that?
Representative Owens, I just might chime in. I don't remember that topic specifically, but I do remember them talking about how only about 50% of the people currently incarcerated in the prison are receiving the treatment needed. And so by adding this piece, it would affect the rest of those people. So I only say that because I wonder if there is some treatment already going on there in the women's prison, that this would just allow the expansion in the male population and would move some of that over. So just some consideration.
Since you raised it, we'll take 1 second here. Randy Bowman, if you're still on, or maybe Secretary Zamut has joined us, but as to that point that Representative Owens just raised, is there, I'm not going to change the recommendations here at this point, but for everyone's edification, is women's treatment on the table? Is it already taking place to some extent? Is it something we're going to want to do? Again, also overarching this whole discussion is the ongoing plan that we're going to ask for another year for this commission. May or may not be granted, but that might be something we take up in the next year. But while I've got everybody here, either want to raise that or address that rather.
Yeah, I think I'll try to answer the representative's questions this way. As we've talked with committees like House Corrections for the recent years, we lack the sufficient capacity, or what we call our unmet needs, for all of our populations, whether that's in the community or the facilities. But yes, there is programming that happens in the Topeka Correctional Facility today. Like the men, we need more capacity to increase that.
Okay. All right. Number 2, on the Specialty Prisons Working Group, the authorization of funding and authority for the modification of an existing facility to provide another 250 male beds for geriatric and cognitive care, the aging prison population. Any discussion as to that specific recommendation? And I'll just take a stab at one thing, jumping back onto what Professor Phillips asked a minute ago. My guess is there's probably the burgeoning, the buildup of the female population is more of a recent advent. So my guess is there's not as many elderly or aging female prisoners as there are male, but that's just a educated assumption on my part. Any other discussion? Okay, number 3, adopt recommendations of the Mental Health Task Force to the 2018 and 2019 legislatures to implement and fund a comprehensive plan to address voluntary and involuntary hospital inpatient capacity needs while providing all levels of care across all settings. Again, for the listeners, Mental Health Task Force is a committee that makes separate apart from this commission that has got recommendations they've made to the legislature that are available online. You can see it's lengthy documents with quite a bit of information contained therein. But any comments as to the 3rd recommendation from the Specialty Prisons Working Group?
Chairman.
Bill Persinger.
Thank you. Served on that mental health task force. I can tell you a lot of great minds were there, not including myself in that list, but worked very, very hard on that and very comprehensive list. I know also there was a children's mental health task force that met at the same time, did address some juvenile issues, and I'm not sure those apply here or not, but maybe in the area of prevention and family strengthening. And then there was also an addictions task force that met that came up with, I think, that would be some relevant recommendations. I don't know if we want to include that here, maybe, in the absence of study by this group, but I just want to make a note of reference. There was an addictions task force group. I think they met late 19, early 20, maybe middle of 19, middle of last year. Just a matter of note, though, if you would, please.
We will note that. I'm not sure, since it didn't get an explicit thing, I'll add it here, but we appreciate the edification and that giving a little more information about the Mental Health Task Force.
Thank you.
Yeah. Anything else with regard to this 3rd recommendation? Okay. Then the 4th, a little bit longer here, you can see on page 3 of the summary, the supervision, or excuse me, no, I'm sorry, I'm jumping over the supervision working group. Derek, was there another recommendation specifically?
Mark, I think that we just bundled them differently. I think perhaps in the current action, we conflated what I called numbers 2 and 3, the substance abuse facility that's repurposed, probably at Lansing, and then the additional substance abuse facility that would be Greenfield somewhere else. So same concept. So I don't know how you want to handle that, but that's the difference in the numbering, I think.
Okay. Well, very good. So I think it's distinction without a real difference here, since there was no constant. I mean, if somebody had a disagreement with something, I think we'd break it apart. But since everybody seems to be on the same page, I'm not going to worry about that. We've put it all out there, though, and everybody knows what we're discussing. So any further discussion about the Specialty Prisons Working Group recommendations, whether we break it into 3 or 4, we're talking about rehabilitation beds. We're talking about both in the facility and then in the community. We're talking about male beds for geriatric cognitive care, and we're talking about the endorsement of the Mental Health Task Force recommendations to the 2018 and 2019 legislatures. Any further discussion about any of those points?
Mr. Chairman, Todd Ackerman here. Do you want the motion to read 3 or 4, or does it matter to you?
I'd say, I'm going to just go, in case someone wants to reference back, we have a document that we're attaching this to, and that's the summary that KLRD, Kansas Legislative Research Department, put out and I'm referencing here page 2 of that 8-page document. I think it breaks it down into 3 bullet points, so we'll say 3.
Now I'd make that motion to accept all 3 motions.
Chief Akron has a motion. Do we have a second?
Sheriff Carr, second.
Sheriff Carr seconds it. All right. Jordan, if you'll do the roll call vote then, as the chair of the commission, my vote is aye.
Thank you, Mr. Chair. Jordan Milholland, KLRD. I'll continue with our roll call vote. Representative Owens.
Aye.
Senator Haley.
Aye.
Senator Wilborn.
Aye.
Representative Finney.
Aye.
Chief Ackerman.
Aye.
Judge Brown.
Aye.
Sheriff Carr.
Aye.
Judge Clark.
Aye.
Professor Francis.
Aye.
Chad Harmon.
Aye.
Spence Cohen.
Aye.
Tabitha Owen. Sylvia Penner.
Aye.
Bill Persinger.
Aye.
Professor
This
Phillips.
is Tabitha. Sorry, I couldn't get my mute off, but I'm also an aye vote.
No problem, Tabitha. Thank you for letting us know your vote. I believe I'm on Professor Phillips.
Aye.
Pastor Roberson.
Aye.
Shelley Williams.
Aye.
And are there any members I've missed? Okay, I believe that concludes our roll call.
Moving to page 3 of the summary, we've got the supervision working group. I was making notes as Shelley was going through the recommendations, and there, if we try to parse these out best I can, following the lead of the summary. We've got the following supervision-related legislative initiatives, and we adopt the Kansas Association of Court Service Officers legislative program that would amend KSA 8246. I think this was also from last year's 2019 report as well, which would allow community corrections and court services to provide identification certificates as a form of identification for the folks that are that they're supervising. I think the point was explained last year that you can do that. Correct me if I'm wrong. I think parole officers have the ability to do that now, but if people who are on pre-incarcerative supervision would have this ability to get their IDs, would help them potentially with employment and housing and other things. And so that was endorsed last time. Number 2 of that bullet point here, I guess the second one would be adopt the Kansas Sentencing Commission's legislative initiative in support of earned compliance credit and the strengthening of early discharge mechanism. That's already been a point of discussion. I guess I should have asked, was there any point of discussion? You have any questions for Shelley regarding the first one, the change to 8246? Seeing none, I'll jump down to the one I just said, which was the earned compliance credit and strengthening for early discharge mechanisms. Notes I made while we were going through that initially had to do with, Representative Owens asked about what had been last year's House Bill 2052. And this had to do with, and Scott Schultz explained, this had more to do with, instead of just a pro forma 50% good time, it was an opportunity for people who were doing well on probation to go back before their sentencing judge. They've been placed on a 2-year probation, and after 1 year, they're doing well. They're in compliance. They've completed treatment. They've paid their restitution, whatever one deems to be success, and they have a chance to go back before their own district court judge and ask for early release. Am I getting the gist of it, Shelley? Or Scott?
Correct. Yes. One was
any discussion? I'm sorry.
No, you're fine.
Scott, anything to add to that?
Nope.
Scott Schultz. Okay. Any discussion about that? Okay. I guess I would just, I know that from the prosecutor's perspective and probably from the sheriff's perspective, just because of, well, maybe not so much for the sheriff, because if you're successfully, probably not in jail, but I could see the some recommendation and maybe a balloon amendment, some sort of a tweak to it that would allow this to happen without maybe a formal hearing being made only upon request from the prosecutor or something. So if everybody's in agreement on this, there wouldn't be a need for a formalized in-court appearance. Maybe this is something that could be journalized, but I'm just thinking of the number of extra hearings that this would require. So just a point to address, but not a reason not to do it. Number 3, support the creation of a work group to create standardized conditions of supervision. I think Shelley already made a pretty good explanation of that earlier today, where she said, depending on which jurisdiction you're in, the conditions of supervision that you are subject to may be markedly different across the state, and trying to have some degree of uniformity would be helpful. Any discussion or questions for Shelley on that?
Chairman Bennett, this is Jean Phillips at KU. Can I go back to the Sentencing Commission one right above that?
Yes, ma'am.
So maybe I just didn't take good enough notes or hear correctly. Is there any, Scott, for the Sentencing Commission's initiative, is there any, is it all just judicial discretion as to whether or not to give a reduction? Are there factors that they look at? Are there standards, or is it just their discretion completely?
Great question. This is Scott from the Sentencing Commission. We actually did go through, and that was a question that was raised in terms of what exactly does substantial compliance mean, giving the court some direction as to what that actually means. What we have drafted includes factors that they can consider to determine whether substantial compliance with probation exists. There are several of them, such as history of compliance with terms and conditions of supervision, payment of fines, costs, and restitution, successful completion of any required program, and that folks such as those on Senate Bill 123 are not eligible for early discharge just because of the length of the program that they would be involved in is at least 18 months.
Thank you.
Any further discussion? And please, as Professor Phillips just did, if you are going back through and trying to keep notes and want to go back to something, I'd rather air it out now than have a problem later. So let me know. 4th here on this set of bullet points, support the creation of a working group to examine the policy to consolidate concurrent supervision cases. I think the notion was people who were both on probation in court services and community corrections. Correct me if I'm wrong, Shelley. This would also be people who may be on parole and probation at the same time. Would it also include people who are on probation across, I guess you already do this, across jurisdictions if you're in 2 different counties, that sort of thing. But just the idea is meet with one PO, have one set of rules you're supposed to comply with, simplify things, streamline things. Is that the gist of it, Shelley?
Correct. And I think it needs to be flushed out about if it's just in one jurisdiction or if it includes multiple jurisdictions within the state. And then also, how do we factor in municipality probations as well? So all of the above.
Okay. Any questions for Shelley about that recommendation? Okay. That was by my count, number 4. Number 5, support the formalization of KDOC's approach to parole supervision violations, including implementation of effective responses to behavior. This is one where I'm going to get out over my skis quick. I'll let you summarize that again for us, if you would, Shelley.
Sure. The Kansas Department of Corrections, through parole, is in the process and already has begun utilizing a 4-to-1 management system. The Carey Group created it, and it's going to be attached to their new database, Athena, and essentially it is how they are going to utilize and distribute both incentives as well as sanctions to behavior for those on parole, and just really looking to that with legislative support and study it further as we move forward with some of the implementation of the reform to see how that might be implemented both in community corrections and court services. So just really exploring it, but the first approach would be to adopt it for parole.
Any comments or questions? Professor Phillips?
This is Jean Phillips. So Shelley, is it just for parole and not post-release supervision, but just for parole?
So the parole would be those post-supervised parolees.
I apologize. I may have been the only one, but it sounded like you kind of cut out there. To answer, did you say both parolee and folks on post-release as well?
It would be the parole, those that are on post-supervision from KDOC initially.
Okay. The reason I asked the question is there's a kind of a fine legal distinction between parole and post-release, and that's not, they're not exactly synonymous.
So this one would mainly address the parolees then, for legal terms.
Okay. Any other questions, Sheriff Carr?
Mr. Chairman, Sheriff Carr. Quick question for point. Is this a statutory addition or is this something on the administrative rules from DOC?
It is my understanding that would be on the administrative rules under KDOC.
Thank you.
All right. Any other questions for Shelley on that one?
Patrick Armstrong, Council of State Governments. Just a point of clarification. This is under the 5 legislative bullets, and that is where it stands. But Shelley's right in that it started as an administrative regulation from KDOC, which is why the Commission wants to support it and have the legislature formalize it through statute.
Okay.
What Patrick said. Thanks, Patrick.
There we go. All right. The second bullet point with then there'll be 4 sub-points to make here, but the second larger bullet point is in terms of recommendations is the following recommendations be implemented. One has, I guess, will be the 6th one overall here. Develop an interagency re-engagement unit. Shelley, you want to give us any more about that one?
Just we are recommending to look to pilot that in 1 rural and 1 urban area in the state, and realign resources in the hopes that we could take it statewide based on the evaluation of it to see if it was effective or not.
Re-engagement meaning directed at folks who are not engaging effectively with their probation.
Correct. Those that have kind of dropped off of supervision and hopefully catching them before they are deemed absconders.
Okay. Again, this more of a funding. You need bodies to stand this thing up. Is that really what we're asking for?
Not right now. Eventually, that it wouldn't be a funding issue. We are looking to do it right now with existing resources within 1 rural area and 1 urban area, maybe by just realigning some resources, doing some shared resources between interagencies. And that's kind of speaks to the other 2 where that interagency collaboration comes into play.
Okay. Again, so the second 2 are, so in that regard are 6, well, the next, formalize interagency collaboration, support interagency collaboration, and formalize the use of effective responses. Is this all really one recommendation?
All but the formalize the use of effective responses to behavior, I would say that's something that parole and community corrections are pursuing at this time, and something that I believe, and Spence Cohen with OJA might speak to it a little bit, but kind of wanted to see how that rollout and the implementation and went with those effective uses or effective responses to behavior.
Okay, so for Jordan and Bob and folks that are going to be putting this into a report, we'll vote on this here momentarily, but looks like development of interagency re-engagement unit, formalization of interagency collaboration, and support interagency collaboration. That's really one recommendation. And then the seventh of the supervision working group recommendations would be formalize the use of effective responses to behavior, as you just explained. Any questions for Shelley as to any of those recommendations?
Chairperson Bennett.
Yes.
This is Jordan with KLRD. I just wanted to clarify. So could we actually maybe make one statement with the three of those in one bullet point, and then add the second one as its own separate bullet point, maybe?
I think so.
Okay.
Chairman
Bennett, Jennifer Casello with the CSG Justice Center.
Yes, ma'am.
If I'm able to provide a little clarification.
Sure.
Perfect, thank
You
you.
want to get it right.
It's okay. If we look at the further down in the full report, the first interagency collaboration is focused on information sharing between the three supervision entities, as well as training, quality assurance, and continuous quality improvement measures to be able to increase efficiencies, as well as leverage expertise within each of the agencies for the benefit of all community supervision agencies statewide. And the second interagency collaboration piece is around access to programming. So that would be reflected around trying to figure out a system to provide programming, particularly for the high risk and high need population, regardless of which agency they're being supervised for. So leveraging resources across all three supervision entities to target that high risk, high need population.
And I do think, Mr. Chairman, this is Shelley Williams again. Upon further review, it might, since they're each going to take an individual memorandum of agreement or understanding between the supervision entities, that they might be able to be voted on collectively, it might make more sense to break those out.
Okay, well, we'll just leave them then as the bullet points that they were to begin with. Okay, so we'll, by the time, so develop an interagency reintegration unit or engagement unit, rather, 6, formalize interagency collaboration is 7, support interagency collaboration is 8, and then formalize the use of effective responses to behavior be number 9.
Chairman?
Yep, Bill?
Bill Persinger, Topeka. Shelley, quick question about, was it appropriate responses to behaviors, that last bullet that Chairman just read? Did I have that phrase right?
Formalize the use of effective responses to behavior.
Effective responses to behavior. Are there, that phrase, are there programs or best practices out there that just help us think about that a little bit? Are those mental health or addictions interventions or preventative measures?
So yes, they're within core correctional practices within supervision. There are some foundational and evidence-based practices in response to behavior. Specifically, the CARI group has implemented a 4-to-1 behavioral management program, and it is actually a database that will be attached to existing databases that will be able to access. And as I understand it, it'll be a guide in how supervision officers respond to behavior, whether it's positive behavior or negative behavior. The 4-to-1 will help in the implementation of those across the state with the supervision officers, at least initially with parole and community corrections. Does that help?
Yes, it does. Thank you very much.
Okay. The following topics should be studied further are the final 3 recommendations. So correct me if I'm wrong, Shelley, I'll read these sort of into the record, so to speak, but you're not asking for formal steps to be taken by this body in terms of a formal ask of the legislature?
Correct.
Okay, so the final three would be ensuring statewide availability of robust sanctions and incentives, data integration to merge siloed data, although I would say that one's probably already been encompassed to some extent by the data subcommittees, and maybe not, but it might be covered by that. And then supervision entity, mission and vision statements, which should be aligned with implemented best practices and goals of supervision. So in terms of, if everybody's keeping track at home here, but what I've got are 9 separate recommendations coming from the supervision working group that the legislature takes specific action with 3 topics that they recommend should be studied further by the legislature. Are we on the same page?
Mark,
Yes.
may I clarify?
You can.
Thanks, Jordan Milholland, KLRD. I just wanted to be absolutely certain that we'll leave this in the subcommittee working group report, but we will not include it in the, if the motion passes, and it's not going to be considered part of our list of larger recommendations for the legislature. Is that?
Which, when you say this one, which one? I want to make sure I'm clear with you, Jordan. Which one are you saying would not be included?
Sorry, I should have been more clear. Talking about the topics that should be studied further, the last item. So we'll take this off of our list of recommendations that'll be in our box at the beginning of the report. It sounds like that's what you guys were agreeing upon.
Well,
We're going to vote.
you raise a good point. Let's ask, do you want it included as a specific call the question? I want you legislature to consider this, or is it just something to be included in a report? What's anyone's thoughts? I don't mean to put you on the spot, Shelley, but what do you think? Or anyone else?
Well, essentially, those were items that we ran out of time to deal with and address. They were things that were important to the work group. I guess I would probably lean to Patrick or Jennifer on their expertise on how they think that it should be listed, if anywhere, in the legislative platform.
This is Jennifer Casella with the CSG Justice Center. During the supervision committee meetings, we had discussed, that these are potential items if the Reform Commission is extended for another year, that potentially they would continue to take up. So as a need for the Reform Commission to continue on at a minimum another year, as well as I know there are some discussions around the re-engagement unit being a pilot, and if outcomes are favorable, then is that something that the Reform Commission would want to look at expanding statewide, which would probably require some resource adjustments. So more of a need for the commission to continue to be engaged.
Well, when you couch it like that, Senator Wilburn, Representative Owens, Representative Finney, Senator Haley, you're going to be on the legislature. Would you think that parsing things out and saying, here's recommendations for the 2021 session, and here's a list of things that we believe need further work that we would like another year to address? We've already got 3 here from the supervision working group. We've got another 1, 2, 3, 4, 5 from the diversion working group that aren't specific recommendations, but we could sort of use this work to make the case for another year. Any thoughts in terms of, I'll be presenting this thing to you and others. Am I overthinking this, or does it matter how we couch it?
Could I ask a question also in addition to that, just for a second?
Sure.
I was wondering too, some of the bills, this is Representative Finney, that went through either House or the Senate last session. I was wondering if those bills could be like pre-filed in addition to separating, these are our recommendations, these are, things that we're considering. But since they have already got, blessings, I was just wondering if that is a possibility to do some pre-filing of the bills that have already been blessed on one side of the legislature.
Representative Finney, this is Representative Owens. I can tell you that I've already started compiling a list and poor Natalie is about to get hammered by my list, and many of those are on there that made it through halfway through the process last year. that I want to hopefully get a jump on very early in this session. So I think so.
So is that just your specific subcommittee or for the overall?
I have been working on a list kind of for the overall based on some of the things that were passed. I can certainly converse with you to make sure that we have all of those covered. But the ones that I've been working on aren't just specifically from my subcommittee.
Okay.
Just ones really that I was actively involved in helping through the process last year that I know only made it halfway through.
Okay.
So I think the answer is, yes, anything that we've got that comes out that we endorse again, and I don't have any reason to believe so far I think we've endorsed everything we endorsed last year. I expect we probably will. There's no reason those couldn't be pre-prepared and ready to file the first day of the session, whether it's Representative Jennings' group or Senator Wilburn's or whomever. Obviously, the new legislature, they'll give committee assignments again. I'm gonna have to wait for all that to fall out. But yeah, I think a lot of that could be done. Was Senator Wilburn, were you gonna say something?
Yes, sir. I'd like to thank you, Chairman Bennett. We also could file a companion bill coming from the other side that was a mirror image. And that way, when we met in the middle, we would cut the traffic down a little bit and go straight to conference to accelerate the process. That's a thought also.
Yep, that works.
I second that idea.
Yeah, that's really a great idea.
Yes.
And would be happy to work with you on that. Chairman Bennett, Representative Owens, if I might, your original question was, does it make sense to have specific recommendations for this year and then certain topics that need more research by adding another year of the Criminal Justice Reform Commission? I think that that's really a good idea on specific topics and certainly warrants a conversation. I know especially the one of my recommendations as it relates to the felony possession to misdemeanors is one that would probably fall into that category to that this committee would like to have further study on. I know that we had a great presentation in our subcommittee, but hearing from some of the sheriffs and law enforcement, it might be one that falls into that. So I would think so, just for consideration.
Okay. Well, what that would look like then, Jordan, would be those last three for the supervision working group would fall into that recommendations for another year category, as would the final 1, 2, 3, 4, 5 coming out of the diversion working group. I know there are some others that we haven't gotten to yet, some other subcommittees that have some similarly situated recommendations, things that are, there's one category of things that are specific recommendations to the legislature for this year, and others that are just, we want you to think about. So,
Mr. Chairman.
Shelley?
With that being said, I think it does make sense to have the legislature at least direct the exploration or continued exploration of those unresolved topics. And just one final thought to circle back around to what Mr. Persinger asked. The behavioral management, the 4-to-1, really speaks to ensuring swift and certain responses to behavior. So it kind of brings that back around. So thank you, Mr. Chairman.
Mr. Chairman.
Bob
Gallimore, KLRD. I was just going to jump in here real quick, if I could, procedurally, and suggest, since we have the luxury of another meeting coming up here in a couple of weeks, you have a number of recommendations that you've already specifically approved today, and probably will have several more. What we can do between now and then is we will work up the list of what that box would look like in the final report. We can send that out in advance of the next meeting so that everyone has an opportunity to see that. And if there's any issues with the way it looks or the wording, you'll still have a chance to make any tweaks you would want. And with that, what we can do is work up a draft language, basically a recommendation, the legislature continue the commission for another year to study these study topics that you haven't voted on today, but that it sounds like you might like to go ahead and include in that final report. under that sort of heading.
I think that'd be great. That's the, like I said, the luxury of another meeting. We can, by the time we're done today, I think you'll have a good framework. You can pass it around. We'll talk one more time, and anybody, if it looks different than we thought, then we got a chance to clean it up. Okay.
Chairman Bennett, if I could real quick, this is Natalie Scott from the Office of Reviser of Statutes. I just want to make sure that particularly the legislative members on this group, as well as you, are coordinating with your requests for bills. So individual legislators can pre-file bills after the election results are certified, but committees cannot. And so, Representative Owens mentioned getting me a list of bills. You guys need to decide, do you want those bills to be pre-filed by Representative Owens individually, or do you want to go to a committee to request the introduction? I just want to make sure you guys are coordinating that so that I don't get multiple requests from all of the legislators on this committee for the exact same legislation. So you might think of how actually you want to accomplish that, either this meeting or the next meeting.
I think that we can discuss that. It's a procedural matter. As long as we're all on the same page about what the bill, what we're putting forward, that's what we're getting done today. I have faith that we can get with the folks in the legislature and figure out the best way. I saw Professor Phillips. Were you raising your hand?
When we're done with this conversation, there's one thing before we vote that I wanted to suggest, maybe a friendly amendment, if this is the time to do that.
Now's the time.
I think that we should change that, support the formalization of KDSC's approach to parole supervision and make it parole and post-release supervision. Just sort of listening to the conversation, I think those terms have been used interchangeably when they're not actually perhaps interchangeable, and we should make it clear, especially since, if I understood Patrick Armstrong with Council of State Governments, that this is a part of the legislative initiative, and if we're going to create legislation, it should be very specific to include both post-release and parole.
Understood. And so let's discuss that. Randy Bowman or Jeff Samuda, is there a reason that they were parsed out, parole as opposed to parole and post-release synonymous?
Patrick Armstrong, Council of State Governments. Randy, if your list, I see you hopped on. Just for context for Randy, because we have been working with other folks in KDOC on this. This relates to the parole policy that was changed around April 20th as it relates to technical parole violators and how parole officers deal with them, and how making decisions on their behavior in order to help them change their behavior. There was a change in who can come into KDOC that parole officers had to follow. Does that ring a bell to you, Randy, or am I speaking gibberish?
No, I was going to have to just let the chairman know. I could get a question to the right people here, but that's not in my knowledge wheelhouse.
Okay. Anyone else have anything to say on that point to Professor Phillips? She couched it friendly amendment. Since we're meeting again on the, go ahead. I'm sorry.
I think it would make sense to include both. I think that would help clarify things.
So we can do that, or Randy, I'll ask directly, would you rather we wait on that one to make sure that doesn't cause some violence to your efforts there? I don't want to put you on the spot. Would you rather take that up, that a friendly amendment up on the 23rd when we meet again?
So I'm texting with Deputy Secretary Cooper, and she says it needs to be both parole and post-release supervision.
All right.
How's that for quick?
I'm telling you, man, text is a wonderful thing. So, all right. Well, thanks, with everyone. That, yeah, we'll make sure that, so Jordan, Bob, etc. Everybody's taking notes here. That when the motion is made, that we'll read both parole and post-release. So, taking a lot of time to discuss the supervision working group, but I figured that would be the case. This was a lot of very important stuff here. Any further questions, comments about anything on this? Again, page 3 of the synopsis that the Legislative Research Department put out ahead of time. Any other questions or concerns about supervision working group? I've got 9 direct recommendations for the legislature and 3 that we're going to set aside for 2022. Well, the 2022 legislature, assuming we get another year. Anything else? With that, then I'll ask for a motion to endorse those 9 specific recommendations with Professor Phillips' friendly amendment on what I show as number 5, and making parole and post-release both included in that recommendation. Do I have a motion?
So moved. Jean Phillips.
Professor Phillips so moves. We have a second.
Second.
Representative Finney is our second. Jordan, if you would go through the roll call. First vote is Mark Bennett, Chair. Aye.
Thank you, Chairperson Bennett. Jordan Milholland, KLRD. I'll continue the roll vote. Representative Owens.
Aye.
Senator Haley.
Aye.
Senator Wilborn.
Aye.
Representative Finney.
Aye.
Chief Ackerman.
Aye.
Judge Brown.
Aye.
Sheriff Carr.
Aye.
Judge Clark.
Aye.
Professor Francis.
Aye.
Chad Harmon.
Aye.
Spence Cohen.
Aye.
Tabitha Owen.
Aye.
Sylvia Penner.
Aye.
Bill Persinger.
Aye.
Professor Phillips.
Aye.
Pastor Roberson.
Aye.
Shelley Williams.
Aye.
Are there any members I've missed? I believe that finishes our roll.
We've got about, it's 3:45. If we could, I had it scheduled to our meeting to finish up at 4. But if people are willing to stick around an extra 15 minutes or so, I think we could probably at least make some headway into the mental health subcommittee. Because we also have on the 23rd, we've got the proportionality subcommittee, which I think will take some time to discuss. So I'd like to, if that works for everybody, we'll keep trucking here, and with the next 20 to 30 minutes, we'll try to get this wrapped up. We got ahead of schedule, but we needed to take the time on supervision. So hearing nobody, seeing nobody waving their arms back and forth, and again, silence is a wonderful thing here. So mental health substance abuse subcommittee, we've got the number 1 is the mirrors the diversion working group to reintroduce House Bill 2708. Number 2, make access to regional mental health services a legislative priority. 3, consider the Council of State Governments Justice Center recommendations. 4, the one about misdemeanor level for drug possession. I'll tell you what, I can go through all of these here very briefly. 5, support statewide implementation of co-responder programs. 6, emphasize prevention of crime through programs that offer protective factors. 7, consider implementation of a sequential intercept model. 8, the health liaison within local jails. 9, support access to detox and evidence-based treatment. 10, support the specialty courts. 11, consider establishing on-site behavioral health services in jail. 12, cost avoidance studies. We encourage that. 13, consider application for Centers for Medicare and Medicaid Services. 14, consider support for mobile competency evaluation, restorative providers. And 15, emphasize mental health, substance abuse, workforce development. So that's an awful lot there. I went through those quickly just to kind of put it out there. I'm gonna call one question here to get started though. Representative Owens, I'll ask you what I call here number 4, support amendment of the level of personal use to the misdemeanor level. You mentioned a moment ago that may be something that we should pull back and hold on for another year for further discussion. You want to go ahead and do that, or do you want to we can see what everybody thinks. I mean, if everybody's on the same page, I guess we can endorse it now, but any further discussion on that one? That one struck me as the one that jumped off the page is probably most ripe for discussion.
Yeah, I as I kind of thought about that and what that looks like, I think that I think that is an opportunity to dive in further. However, I would certainly be interested in other people's opinions on that one.
Okay. Well, let's just go through these one at a time real quick. So the first one, House Bill 2708, this commission, this today, we've already endorsed that. So anybody have any further discussion on that? I think we've already agreed on that. Number two, make access to regional mental health services a legislative priority. My Lord, I hope they do. I mean, at this point, after a year of this, if that's not on there, what are we doing? So wave your hand, jump in at any point if you want to say something, but I think I'm reasonably sure we're on the same page there. Number three.
Bill Persinger.
Bill, please.
Thank you. Bill Persinger, Topeka, Vallejo. I'm thinking that reference to regional a couple of times refers to access to the state psychiatric hospitals. And that is, can be a bottleneck for affecting a lot of our professions and of course our patients as well. But if folks wonder what that regional is about, my own personal opinion of that is it says state hospital access to me, that being the moratorium on voluntary admissions.
Well, I'm glad you raised that. I'm not sure that that's, yeah, I don't know that that's what's meant. I think it has more to do with the fact that everybody across every region of the state should have access to mental health services, as opposed to that term of art as you described it.
Agreed. And then, as a friendly amendment to that, because the mental health centers and the state hospitals, we are inextricably tied together. And that also spoke to me about that. We might want to put the word local in there as well. There are some individual counties, and if you're in a 3 or 4 county mental health area, that's kind of a local, so maybe local and or regional, but I would defer to my fellow committee members and Chairman Owens on that.
So Professor Phillips, I'll get to you in a second. Steve, are you okay with that minor amendment that read regional and local?
Yep. This is Tabitha Owen. I think it's interesting, Bill, that is what you thought, because when I read it, I thought, okay, so we're talking about access to local mental health services just in general, not necessarily the hospital, but just being able, because I'm in a rural area, the rural perspective is so different, and regional to someone in Shawnee County might literally mean in Shawnee County, whereas regional to someone in Smith County means anywhere in our 13 county area. So it's really not regional, and people, are trying to figure out how to get to a mental health provider that's over an hour away, and they don't have reliable transportation, and there's a bunch of barriers there. And so when I read that, I thought maybe, hopefully, wistfully was thinking, okay, we're talking about making mental health services in rural and frontier areas a priority.
And I would agree with that. And there were just several other references to, more local programs, and, the 2018 Mental Health Task Force report covers a lot of territory. But Chairman Owens, I'm sorry for not, speaking more definitively on that earlier. I should have probably, raised this question earlier, was asleep at the wheel on this one. But I am certainly, glad if we could consider a discussion of a broader scope of the whole continuum of mental health care, including access to the state hospitals. It really is difficult to separate one from the other. Tabitha also does make the point that for some mental health services, it is regional, like the community crisis centers, in Shawnee County, and really Riley and other counties as well. If somebody's in your area and it's a crisis, they're your person no matter where they're from. But I just, that might get to be a ballooning area in terms of the kind of programming and cost but.
Understood. The point is we just want to make sure it's clear that we're not just talking about Osawatomie and Larned. We're talking about local access, people making access to mental health services more readily available to all the citizens across the state, regardless where you're at.
Correct. And to Tabitha's point, I might say if we're going to add that phrase mental health services, consider adding community mental health services, since that's that safety net that we're talking about, in addition to our fellow professionals in law enforcement and other areas. So if there's no objection, I just consider that as a friendly amendment. Chairman Owens, again, I apologize. I should have been sharper on that matter.
So let me see if I'm on the same page with what you're thinking here. So we could change that last sentence to, with this in mind, we highly encourage the legislature to continue to make access to local and regional community mental health services a priority.
Yes, sir.
Am I understanding that correctly? Does that help expand things enough for you as well, Tabitha?
Yeah, I think so. I think that at the end of the day, where all of us are in our subcommittees, is that we just don't have enough time to flesh out real pinpoint ideas and plans to make these things work. So we're saying here, we want you to focus on these priorities, but we also want more time so that we can come back to you and say, here are some ideas about how we can really get these services in a rural community and how we can really get these services and get, I guess, as Bill was speaking about, the moratorium lifted on the hospitals. Right now, we're just saying, please, pay attention and know that these are issues that we have, but obviously we still have a lot more that we want to dig into and come back to you with, right?
Okay. Professor Phillips, you had something you want to raise? We got it? Okay. So we left off, number 3, consider state government's Justice Center recommendations as adopted by the Mental Health Substance Abuse Subcommittee concerning the support of people with co-occurring disorders. Any discussion there? Steve, you want to add to that? Representative Owens, sorry.
No, you're fine. Steve always works for me. So you can look at these specifically, and as you dig deeper into them, there are very specific recommendations in there. Many of them are policy related that we could spend an hour talking about each one of them all over again. Overall, we had this conversation with CSG. We went over these, we discussed these, and so we just choose to put them all in there because I think everybody's on the same page with them.
Okay. Any further discussion? Anyone?
Chairman Bill Persinger, again, I would just second what Chairman Owens said. And, we did try to, list specific kind of behavioral health services rather than just saying, well, let's better fund the community mental health centers, which, I vote yes on that, of course. But, we wanted to be specific and rather than say, well, we need more of this, in general, we tried to pinpoint that down. And I sure appreciated Chairman Owens' time on that, as well as CSG and other members of the committee, to really look at those programs like the PARI program, PAARI, and other interventions that would be specific to this topic area.
Okay.
Just really appreciate the consideration.
Yeah. Next one is the drug possession, making it a misdemeanor. Just keeping in mind the time, I'm going to jump over that one and come back to that and see if we can get consensus on the remainder, then have a final discussion on that one. Support statewide implementation of a co-responder program, number 5. We've heard discussion that Sedgwick County is doing that, Shawnee County. So these pilot programs, I think the bottom line is if the legislature wants to look at it, there's going to be some data to draw from those 2 counties about the effectiveness and the good utilization of those programs. Representative Finney, did you raise your hand there, or did I just see you move your hand?
I'm sorry, I was shooing a fly.
Well, that's okay. I answered a shoe fly too. So, all right. When a legislator waves her hand at me, I stop what I'm doing. So
sorry.
That's all right.
Chairman,
any discussion about the co-responder program?
Mr. Chairman.
Oh, please.
John Francis.
John Francis, Washburn Law. This is a proposal where I think, like many of these, it does seem like there will be a negative budgetary impact, but I think the data that we looked at shows that there's a significant savings in diverting people away from being arrested, diverting people away from jails. And so even though there would be an expenditure of money up front to get co-responders working with law enforcement throughout the state, I think the goal is that there will be a net budgetary gain when we look at the impact of this. And I think that's true with many of the recommendations coming from the subcommittee.
Well, there's another thing, and that is, what role does the legislature play in this? And if we're asking them to fund co-responder programs in 105 counties across the state forever and ever thereafter, I think it's probably dead on arrival. But if we say, we'd like you to, using the examples of Shawnee and Sedgwick County, come up with a couple of pilot programs in a few places, fund that for a year or two, show the effectiveness of this, the cost effectiveness of it. And then at that point, it makes it easier for sheriffs and chiefs of police and county mental health directors to go to their respective county commissions, city commissions, and seek grant funds, et cetera. So I think it's all these points are very well made. So,
Chairman,
right,
Bill Persinger, I'm sorry to drag this out a little bit, but well stated, Professor Francis. I would also like to say to Sheriff Carr and others in, maybe more regional, larger regional rural areas is that, the concept of a co-responder program can be made scalable to, jurisdictions like, next door in Wabaunsee County. How do we do that in a, when a sheriff may have 2 or 3 deputies, on duty at any given time? And what about a mental health center main office that's 30 or 40 or 50 miles away, as in the Pawnee area? How can that be done? It is scalable, and so just want to make a pitch for that. And it does fit well too, Chairman, with your remarks. How can we introduce this into maybe 2 or 3 other pilot areas? KDADS has already funded 5 or, not funded. There are a couple, 3 programs, and I think KDADS could provide some input where some others might exist as well. But real scalable and practical and public safety oriented, if you ask me. Thank you for the time.
Yep. Protective factors number 6.
Mr. Chairman.
Yeah, Bill, sorry.
Sorry, this is Sheriff Carr. I want to go back to that real quick, please. I'm in complete agreement with this. Again, I go back to the possibility of an unfunded mandate. It's I'm fortunate here that I have a phenomenal mental health organization within our county and area. But like Mr. Persinger pointed out, these smaller communities, this is hard. And again, I'm also going to go back, I'm going to continue to hit on it, is the lack of the professionals that we have out in our areas as well. So few mental health professionals we have out in Western Kansas. What are we going to task them with? 24/7 access to pick up the ball and cover these other areas. So I guess where I'm going with that is maybe rewording that is something to the effect of support as statewide pilot program implementation rather than just an actual statewide. But we grow it, as Bill said, in increments to see how it's working. Is that more sellable to the legislation? And I would,
I wouldn't get too hung up on the specifics right now in this. That this is a policy thing we're putting out there, and I think you could even say support the statewide effort to implement funding of a co-responder program. It's a fairly benign statement, other than to say this is a good thing. You need to look into this, and I don't think anyone's going to read this to say, yes, we're demanding all judicial districts, all counties start this up and the legislature is going to pay for it. Like I said, doesn't matter how we word it, that ain't going to happen. But if we make it clear that what we want to do is ask the legislature to recognize how effective this can be and take affirmative steps, whether that's pilot programs or something else, but take affirmative steps to support this. That would be a good thing. So I don't know. If someone wants to be more specific, I'm all ears. But
this is Chief Ackerman. We're from a smaller community, like he's talking about. I have 8 officers here to run 24 hours a day.
Right.
And we have a hard time we are not as blessed with a good system here as Sheriff Carr is. I can sit with a person at the hospital for 6-7 hours just to get one screened. And so I'm all for, as he said, just to have it done. I just don't know how feasible it is in our area, but if they could find a way to do it, we would gladly accept it. It's just feasibility would be an issue.
Chairman Bennett.
Sure.
Bill Persinger again, Topeka. Todd, you and I have, been associates in the past. I've worked up in your area, and Sheriff Carr started my career out in Kiowa County, and I'd invite you both to give me a holler sometime. Maybe we can do a little conference call. I could not speak for your mental health director, Robin Cole, or Lisa Southern specifically, but do have a couple ideas on, what a co-responder kind of program might look like in a more rural area. Be glad to share those ideas with you. But I have 100% empathy for where you're at. I hear you.
I fully support that.
Certainly.
Chairman, real quick. It's important to recognize how these reports work and how they flow into the legislature and how that process works. So myself, it is going to take a member of the legislature to kind of take this ball and get it through the process, right? To pick up on this one item and say, I want to focus on this. So while the recommendation may be that it is statewide, that the funding does follow all of these things, once it's introduced, and let's say hypothetically it is introduced and the funding is introduced as such, those conversations are going to occur in committee meetings where we say, okay, we have a lack of resources to accomplish this, or it's not feasible in this situation. And it's going to be kind of massaged into a workable system, hopefully, if the legislature sees fit. So I'm happy to adjust the wording if that makes sense. But I think the overarching thing is here, look, if we could create a co-responder system statewide, and if we could fund it fully, it would be a good thing for the state, and it would be good everywhere. And I think that's the message that we were trying to get across, not that there would be any unfunded mandate, or not that we actually have all the people to make it happen. But in a utopia, in a perfect world, it would be awesome to have that system everywhere.
Okay. First time we've heard utopia today, so.
Trying to think positive, Mr. Chairman.
All right. Okay, next 6, the protective factors. Safe, affordable, and decent housing, gainful employment, etc. Heard these also referred to as stabilizing factors. The notion of three-legged stool: housing, employment, treatment. You get those things in place, people are going to be more successful. Again, just jumping on what Steve just said a moment ago, we're not asking for anything specific here. It's just a recommendation that the legislature take some affirmative step toward achieving these things. So 7, and again, jump in at any point. No one's shy in this group. Jump in at any point if you want to say something. Number 7, consider the sequential intercept model. Steve already referenced this earlier, but it's again a specific model that's been implemented, rolled out in other areas. Has a sort of a specific term of art, has a specific meaning, but if you want more detail, it's in the report. Any other? I'll stop myself there. Any comments, concerns thus far? Okay. 8, a health liaison within local jails. Again, I think that's kind of like the co-responder program. Not suggesting that we're going to have the legislature mandate that all jails go out and hire a health liaison. Frankly, you could put out an RFP and try to hire people to do it. There may not be any applicants in your particular area because there may not be anybody who fits that bill where you happen to live. But as you said a moment ago, Representative Owens, would that be a good thing for all jurisdictions to have? Absolutely. And if nothing else, we're saying that affirmatively to see what steps could be taken to get closer to that. Any other comments there? Number 9, supported detox and evidence-based treatment. Support access to any, I think it seems an inarguable point to me, but anyone have any commentary there? Number 10, commission fully supports the use of specialty courts. We've already endorsed. Yes, Professor Phillips.
I'm sorry, I didn't get to my button in time. I just have a clarification question on the supporting access to detox. Yeah. Is that the individual still has to pay for this, or is this provided for them at no cost to the individual? Or do we not care at this point?
Steve?
Representative Owens here. I don't think that we contemplated who was paying for it. It was just expanding the access to detox and treatment is going to be beneficial throughout the state.
Right. Okay, fair enough. Thank you.
Chairman, I could respond pretty quickly. Chairman Owens is correct. It was an ideal that we thought all people should have access to. Folks with private health insurance could have access to that. Also, individuals who are unemployed or otherwise indigent have access through state and federal funding, and sometimes Medicaid. Of course, if you expand that, you have to expand the funding base. Right now, it's fixed, and I understand that. But I was thinking of both the public funded client and the privately funded client, that And my main concern, just being selfish about it, but Chairman, I'm sorry, Bill Persinger from Topeka, is just the access by the public funded client, the person who's, maybe the people who are working poor or unemployed or who don't have health insurance or Medicaid, that we have good access for them. But good question. Thank you, Professor. Thank you for the time, Chairman.
Sure. Number 10, the Commission for the Sports Use, especially courts. We've already, I think, endorsed that from Judge Brown. 11, establishing on-site behavioral health services in jails. I think Representative Owens, jump in if you disagree, but I think much like the conversation a second ago about health liaisons, about co-responder programs, this is, maybe a utopian goal, but it's a goal nonetheless, and ought to be included, and we'll see what steps the legislature sees fit to do with it. But it would certainly be, if a jail had access to behavioral health services, things go better. I can say that in Sedgwick County, our sheriff's highly expanded the use of a behavioral health wing, a whole pod devoted to that, and it's been hugely beneficial to the running of the jail. So
thank you, Mr. Chairman. Representative Owens, real quick, I just wanted to point out that I got you to use Utopia as well.
There you go. I'm highly suggestible. Let's see here. 12. Cost avoidance studies, just asking them to do some. I mean, there's a whole host of examples out of Wichita State, I know, because local, so I'm just, cued into that, but I'm sure KU and others have done it. But we can show you all sorts of ways that spending money locally saves money, not only for Sedgwick County, but for the region and the state by plugging in money in certain programs. So I think that's a great idea. 13, the Medicaid, Medicare waivers for reimbursement. Anytime you talk about the M word, you're going to get somebody to raise some eyebrows in Topeka. Medicaid, Medicare expansion. Steve, or Representative Owens, thoughts on that? Anything you want to add to that? Okay. 14, consider support for trained mobile competency evaluations. I know that that's a real issue, and if there was an ability for somebody to come through a region, once a week, once a month even, and see people in a jail who need to have a competency evaluation. Every day somebody sits in jail in Sedgwick County, it's about $80 a day, and if they're sitting there for 6 months waiting to go see somebody at Larned, there's a huge outlay of cash for that. So I think that's a great idea. 14, let's see.
Chairman, I'm sorry.
Yeah, go ahead.
Bill Persinger to speak up. Back on 13, that does address this very specific federal rule called the IMD, the Institutes of Mental Disease rule, that prevents Medicaid from, bars Medicaid from paying for any kind of behavioral health treatment in congregate living type situations where more than 15 people live, whether they all have Medicaid or only 2 of them have Medicaid. It could be a barrier to detox, mental health residential programs. And I don't think we were speaking specifically to Medicaid expansion. It does refer to it, which of course, as you aptly point out, is a whole nother conversation. So,
yeah.
Thank you.
Is that really recommending then a change to federal law then? Is that what you're?
That's correct. I think KDADS, maybe KDHE spearheaded that last year or the year before, where they set aside the IMD rule for substance abuse treatment. Part of the bigger demand is on the mental health side. Can we set that rule aside on the mental health side? And I can just speak to the I part of that. Would soon see that rule go, but would certainly be open to disagreement on that. But there was a little bit of some discussion in the committee about that it is a barrier. And there are people with a good body of knowledge on the technical matters of that, including some folks at KDADS and KDHE, and I would defer to their expertise. But we in the mental health field see it generally as an obstacle to more effective care. And nobody wants to, lump people into, long-term big mental institutions any longer. But we do have some more medium-sized facilities where we could use some care, even in some rural areas, in some nursing facilities that could provide treatment if this was expanded.
Okay. That's good. Good to make that distinction between just general Medicaid expansion, which may be dead on arrival, and this very specific tweak you're asking for. So I appreciate that. I should have been so broad stating that. Last one, number 15, emphasize mental health, substance abuse, workforce development, as everyone has indicated in the rural areas, even in the urban areas. Sedgwick County didn't have enough mental health workers, so clinicians and the like. So, all right, so let's go back to number 4, support the reduction from what's called level 5 felony possession weight for narcotics, any number of them, and make it something more like marijuana. So use weight being a misdemeanor. As Representative Owens has already pointed out, that's could be some folks with some strong questions there or strong concerns. Let's open this up for discussion.
As Chief Hackerman of Marysville, for the Chiefs Association, obviously we will oppose this. Just knowing narcotics, marijuana is one thing, but you start hitting cocaine, heroin, fentanyl, which is huge, killing people right now. To make that a simple misdemeanor, we would definitely oppose this.
Okay. Other thoughts?
Mr. Chair, if I could be heard.
John Francis, Professor.
I realized, this is a big change. And I realized that, meth, coke, opioids, they're not marijuana. I think if a big part of our underlying goal throughout the existence of this commission has been to reduce overcrowding in the prisons, steer people towards sustainable recovery. And I think the big issue with this is that when somebody gets a felony conviction, the benefit of the felony conviction is that it is hopefully a deterrent up front. The downside of the felony conviction is that there are a number of collateral consequences that run with felony convictions. And these collateral consequences can be obstacles to safe, affordable housing. They can be obstacles to sustained gainful employment. They can be obstacles to education and definitely getting funding to higher education. So we have all those together. If people are blocked from that, it has a negative effect on health. And it also has, unfortunately, a negative effect on sustained recovery. And it actually increases the risk of recidivism. There are a number of states that within the past few years, I'd say past 6 or 7 years, have taken the step to reclassify simple personal use possession. And that's really what we're talking about, personal use possession, from felony to misdemeanor. And those states include Alaska, Connecticut, Oklahoma, and Utah. Oklahoma was the most recent. Those states that have done this have seen, first of all, a budgetary benefit. And I think Oklahoma is probably our best example, closest example of that. But there also has not been a dropout in the deterrent effect of these offenses. And so I don't think Kansas would be an outlier by any stretch if we made this change. I do realize this is a substantial change, but I don't think this would put Kansas as an outlier on this. And when we're really looking at the underlying purpose of let's get people who are involved in personal use, possession of controlled substances off of those substances, let's get them into sustained rehabilitation. When we remove these collateral consequences of felony conviction, we have a clearer path towards sustained rehabilitation.
Okay. Further discussion.
This Chief Ackerman, just one thing to that. I would agree with you, Mr. Francis, on several of those things. But the thing to me is I'm all for the rehabilitation. If they get convicted of their crime, I'm all for helping them out. But you would think getting a felony and not being able to have access to all those things that you're listing would be a pretty good deterrent already. But they still do it. Okay, they did it. They get their felony. Now let's try to help them. There's always expungement. There's always stuff like that in time. It's just it comes down to there's got to be a deterrent in the beginning, or what would keep them from, hey, we'll go ahead and try this. We get caught. It's just a misdemeanor anyway. So
if I could just
my opinion, yeah. And that's the way we would look at it in the association.
I mean, what you're saying makes logical sense. I'm not disputing that the deterrent effect should deter people up front. So I think there are a couple of things. Number one is when people are addicted, they may not be thinking in a logical cause and effect process. But what I'd also like to do is just take a look at nationwide how effective the enhancement of drug laws has been throughout this country. So the major war on drugs really kicked in the 1980s, and that's when severity and penalty levels really started to kick up. In 1980, nationwide, there were about 50,000 people incarcerated for drug offenses. The latest data that I have that my research assistant put together is in 2013, there were 489,000 people incarcerated nationwide. And so that is almost a tenfold increase. And so if the deterrent effect was there just by felonizing something, we would have seen a drop in those numbers. And I think bottom line with this is doing the same old stuff has not been a deterrent. Felonizing or having personal use offenses of this type of drug has not wound up being a deterrent. So if that's the case, let's look towards a path that will help clear away obstacles to recidivism. And I think getting rid of some of the collateral consequences that go with felony convictions is a path to doing that.
I guess I'd point out one thing. I think my association is probably going to oppose it as well. I haven't heard for specifically, but I don't think we oppose the concepts that you're supporting. And one of the things I think the response I'll get is the House Bill 2708, the idea of a diversion. And using Senate Bill 123 money for, I mean, the chance would be, okay, let's give that guy, let's get him into the diversion, use Senate bill money to pay for his treatment and see if we can get him, and with that as an added hurdle toward the felony, meaning you couldn't get to a felony if you were given the opportunity for diversion. If that could be passed, that would be one affirmative step. I understand what you're saying. And frankly, I do think that another year where we talk about this more would be beneficial. I also think there's an opportunity to, we'll talk about this when Chief Ackerman's proportionality committee talks next time. I think even adjusting the weights, you go from 3.5 grams to 100 grams. I mean, there's a huge expanse that everybody's lumped in together. But I think there's probably a middle ground here, but I understand both concerns. Senator Wilburn, I saw your hand.
Thank you,
Go ahead, Senator.
Chairman Bennett.
Hang on a second, Tabitha.
This is Senator Rick Wilburn, 35th District. One thing I'd like to bring in here, and it doesn't have a lot of substance, but it does have a play. And there are political ramifications to this as it relates to people voting for this. And once we float something like this out on the floor or in committee, it could jaundice some of the other good work we do. So I hate to talk politics, but that is a part of this deal.
No, it's not. I mean, this is an inherently political endeavor. So, maybe if we get that extra year, the third year is the time we bring out some of the more controversial stuff. Get what we can in this one, since we didn't get it as much last year. Frankly, the goal was last year to get some of the low-hanging fruit. So, Tabitha?
Yeah, thanks, Chairman. This is Tabitha Owen, and I would just echo what you said. I think that the KCDAA as an organization probably would have a hard time getting everyone behind that, at least immediately. I also really can understand where Professor Francis is coming from, and I think he makes a lot of excellent points, and I think that there's certainly a lot of evidence out there to show that maybe lowering the penalty for some of these simple possession crimes is helpful. But like Senator Wilburn said, I think that there's just no way you can get the legislature to swallow this right away, especially when we don't have really any sort of ripple effect things ironed out. We know that this is going to put an incredible burden on court services officers who are now going to take over all of those what would have been felony supervision cases. And so I think that the burden really ends up being shifted in a way that's not really accounted for there.
Okay. Well, I'm mindful of our time here. If anyone has anything else they want to get to, I'm not going to cut this short, but we're already 25 minutes over, and
If
I
could,
hear us. Go ahead.
Just going to say, Mr. Chairman, this is Representative Owens. I just wanted to maybe kind of bring this all full circle, because this was a very similar conversation that happened in our subcommittee, realizing the political ramifications of this, realizing some of the ancillary benefits, because Professor Francis and his assistant did a bang up job of helping me understand why some of the things that we do don't work and they're not the right answer. That doesn't mean that this piece is ready for prime time. I think, as discussed, I think that, and my question to Chief Ackerman and Sheriff Carr is, would you support simply moving this as a recommendation to further study over the next year if this is extended, so that we can dig in deeper to it, and then also look at, okay, is diversion the right answer, like we were talking about substance abuse, or do we need to create more programs to ensure that if these people get misdemeanors that they're getting the treatment? So that would be my question to you guys, if you would support just the idea of further study.
This is Chief Ackerman. I would support a study with no obligation to support, obviously the outcome.
Absolutely.
I don't mind studies at all. I mean, sometimes things are brought to the forefront we didn't even think about, but I would support a study, but not an obligation.
Chairman?
Yeah.
Bill Persinger here. All remarks, I think are appropriate. I can sure see both sides of it, and one of the factors we could consider, and I think we did consider in the subcommittee, was public safety. So if we can get to an individual early on and find a hook to get them in treatment, at what point do we prevent them being encountered later on by a law enforcement officer when they're committing a dangerous felony? And so, I can tell you that we had public safety in mind, particularly of our law enforcement officers, when we talked about this, not as the solution, but as another justification for early intervention and treatment may prevent an individual from committing a more heinous crime later on, where everybody's safety is at risk. But I agree, it needs a lot more debate. It is controversial. There's a part of me that says, whoa, but the other part of me says, goodness, this could really open some doors for people, as long as we don't give up on public safety and we keep public safety in mind. But enough said. I appreciate the time.
Well, again, I don't want to cut the conversation short, but we're running out of time this afternoon, so we got two choices. I think we either take a motion to endorse. I'm going to parse this out into. I'll take a motion to endorse 14 of the 15. The only one not included in this would be number 4, the one about that we just discussed. We'll take that up momentarily. I'm not killing it now, but so we take a motion to that effect right now, unless people want further discussion on all of this. If that's the case, I think we're running out of time, and we'll table this till the meeting on the 23rd. But I think we've got consensus on 14 of the 15 bullet points put forth by the Mental Health Substance Abuse Subcommittee. Do I have a motion to that effect?
This is Sheriff Carr. I'll make the motion to endorse the 14 with the exception of the personal use drug possession charges from felony to misdemeanor.
Do I have a second?
Second.
Chief Ackerman, any further discussion?
Chairman Bennett.
Professor Phillips.
Jean Phillips from KU. My only qualification to that is that we should move that defelonization to one of those bullet points where we're going to study this further, that we're not just booting it, but that we're going to study it further.
Yeah, I'm sorry. I'm doing this one at a time. I'm coming back to that here momentarily.
Okay.
Once we're done with this bill. Yep. So so with that, we've got any further discussion?
Chairman Bennett, Bill Persinger at Topeka. Back to the one of the first topics we talked about. We talked about local and regional community mental health services. That phrase remains in our motion.
I understood that Representative Owens had added that, so that when Sheriff made his motion and Chief Ackerman seconded, I understood that was part of it.
Thank you.
Okay, so with that, Jordan, if you'll go through the roll call. Mark Bennett, Chair, aye.
Thank you, Chairperson Bennett. Jordan Milholland with Legislative Research. I'll continue the roll call. Representative Owens,
Aye.
Senator Haley,
Aye.
Senator Wilborn,
Aye.
Representative Finney,
Aye.
Chief Ackerman,
Aye.
Jennifer Basinger, Judge Brown,
Aye.
Sheriff Carr,
Aye.
Judge Clark,
Aye.
Professor Francis,
Aye.
Chad Harmon,
Aye.
Spence Cohen,
Aye.
Tabitha Owen,
Aye.
thanks Tabitha, Sylvia Penner,
Aye.
Bill Persinger,
Aye.
Professor Phillips,
Aye.
Pastor Roberson,
Aye.
Shelley Williams.
Aye.
Are there any members I've missed? I believe that concludes our roll.
Okay. Then Professor Phillips's point, I don't know if it's a formal motion, I'll give her a chance to say that, but formally moves, I believe, to move number 4 to that category of recommendations, I think we're calling it at this point, that we recommend be further studied, and that is part of the basis for why the Reform Commission should be extended for a year, because this is a specific thing we want to study. Is that I understand that correctly?
You did. This is Jean Phillips. Yes, that's correct. And I so move based on
Do I have a
that.
second to Professor Phillips's motion?
Second, Chairman.
Bill Persinger.
Bill Persinger.
Okay, with that then, any further discussion? If not, Jordan, we'll go ahead and this will be the final vote of the day. If you'll do the roll call, first vote, Mark Bennett, Chair, aye.
Thank you, Chairperson Bennett. Jordan Milholland, Legislative Research. I'll continue the roll. Representative Owens.
Aye.
Senator Haley.
Aye.
Senator Wilborn.
Aye, and with all due respect to Professor Francis, I do agree with his synopsis. I meant no offense by my comments.
Representative Finney.
Aye.
Chief Ackerman.
Aye.
Judge Brown.
Aye.
Sheriff Carr.
Aye.
Judge Clark.
Aye.
Professor Francis.
Aye. And Senator Wilburn, I took no offense.
Chad Harmon.
Aye.
Spence Cohen.
Aye.
Tabitha Owen.
Aye.
Sylvia Penner.
Aye.
Bill Persinger.
Aye.
Professor Phillips.
Aye.
Pastor Roberson.
Aye. And to Professor Francis, I would like to get more information from you about the conversation based upon the data that I've been looking at, the disproportionate number of people who are incarcerated within the state. So I'd love to talk to you on that outside of this conversation.
Shelley Williams.
Aye.
Are there any members I've missed? All right, I believe that that finished the roll call.
Okay. Well, it's 4:35. When I put this agenda together, I figured that trying to get all the subcommittees done in one day would be optimistic, and I think that's proven to be the case. We were going to meet again on November 23rd, at which point we'll hear from the Proportionality and Sentencing Subcommittee, the Race and the Criminal Justice System Subcommittee, and the Reentry Subcommittee. Anything else we need to bring to the attention of the body as a whole? All right. Well, thank you all for patience and sticking around an extra 35 minutes, but I think we got quite a bit done today. This was a lot that we've undertaken, and I wasn't sure how we were going to parse this all out in 1 month into a final report, but I think we're halfway there, and that's a testament to the commitment of everybody on the group. And I appreciate everybody's comments. And even if we're not on the same page about everything, I think everybody recognizes that there's tremendous validity to all the points that have been raised. So Thank you all. I'll go ahead and close the meeting, and we will see you all on the 23rd of this month. Guys, have a great week. Everybody try to stay healthy. Keep your mask on. See you.
Thank you, Chairman.
Take care.
Well done.